Right, seems some cameras on. That's fine, thank you. Good morning, everyone. That's at 9:30 on the 3rd of March, and we're ready to start the first of 3 hearing sessions today. We're hoping that these will run on one into the other with sufficient breaks made between so that we can prepare for the different topics. I explained the context for these hearings at the start of the inquiry session on Monday, and I'm not going to introduce the whole inquiry and all the rules again. You can refer to that recording if you're interested. We'll be taking breaks. I'm hopefully going to try and just keep the breaks to between the hearing sessions if possible, just to stay as focused as possible on the topics that we're dealing with. I'll move on to the hearings in due course, but we do have some business to deal with from the inquiry sessions, which I thought might be useful to deal with first. But perhaps we can just introduce who's here just now. My name's Elspeth Cook. I'm the reporter with the Department of Planning and Environmental Appeals, and I'm appointed to consider the case and report to ministers. And perhaps the applicant could introduce who's with him today.
Thank you, ma'am. My name is Marcus Trinick. I'm a solicitor, Queen's Counsel. I will be speaking today in the policy hearing session, and most of the talking will be done by Alison Sidgwick, a planner of Stevenson Halliday, who is on screen. Thank you.
Morning. And the council?
Good morning, ma'am. My name is James Findlay, Queen's Counsel. Today on my left on the screen that you have is James Hewitt. Now, James Hewitt has replaced Elizabeth Tully, and everyone's had notice of that. But what I realised this morning was that you haven't had notice of his qualifications. I've had an email sent round this morning, but if I just introduce him, when we come to that session, I'll introduce him more fully. But there will be a note of his qualifications coming round. And over my left shoulder is Arlene Gibbs, who's instructing me, and over my right shoulder is Ewan Brown, advocate, who's assisting with all 3 sessions this morning.
Okay, thank you. And then we have other parties. Ms. Shaw, I saw earlier.
Good morning, ma'am. Susan Shaw, I'm a solicitor. I appear here on behalf of Wildcats Haven, and I don't think my client's present today, but they may be watching the live stream.
Yeah, I saw Mr. Woodfield just appeared in the participants just a moment ago. And then have a member of the public, Mr. Hammett. Have you managed to rejoin yet? Mr. Hammett was having, oh yes, I see he's there. He's having problems with his camera. Not answering. I'm not sure if you're there, Mr. Hammett, but it indicates you're on mute. So, oh, there we are. Oh, switched off again. No, I think he's there. We'll double check when we start the hearing proper that he's getting through to us. And I saw Julian Newman appear on the participants list. Mr. Newman, would you like to introduce yourself?
Hello, I'm a resident in the Clashindarroch Forest at Bergenclough Lodge. I don't intend to contribute to this session. I will contribute to the later part of the morning, but so far as the issues to be discussed at this session are concerned, I stand ready with Mr. Hammack and quite happy to take him if we need to.
That's great. Thank you.
Yes.
Right. Mr. Hammack's microphone is back on. Mr. Hammack, are you hearing us all right? I might keep going because we've got a bit of business to deal with that doesn't directly involve Mr. Hammack. Maybe keep going and see what's settles down. You recall yesterday I indicated that we would be discussing at the end of today's session the matter of closing submissions, but I thought it might be prudent to do so now, and the issue of expenses that was raised at the end of yesterday's meeting. And just get these 2 bits of business.
You switched. You switched. I can't listen to it now.
Go.
Phone's now on, so we okay, it's muted now. Sorry, I shouldn't laugh. Okay. Right, I think that's settled down a bit from Mr. Hammock's end. So the first matter we'll deal with is the issue of closing submissions and case summaries. Obviously, we've had a couple of discussions about it, and I've put to you that I would like a separate case summary from closing submissions. Mr. Trinick's suggestion was that it forms part of the closing submissions, but is indicated as such in the closing submissions, and that the timing of its delivery would just coincide with the closing submissions schedules that we're about to agree. Does anyone have a view on that? Obviously, I would be expecting closing submissions from Susan Shaw, probably, obviously from the council, and possibly from the third parties that were participating, although their cases are relatively short, so it's not essential for them to provide closing submissions, but they're free to do so if they wish to. Ms. Shaw, do you have a view on the case summary issue and the closing submission issue?
We are supportive of the proposal that it's timed together. That certainly seems to make sense to us, but we're in your hands, ma'am, and obviously are flexible as to what's most helpful to you.
Okay, now the discussion we had that the case summary should be fairly short, and we were looking at around 2 pages of text to keep it as focused as possible. Is everybody happy to understand the purpose of the summary is not the whole case, but the selected highlights, if I put it that way, that you would wish to see presented in the report to ministers? I'm getting nods from everybody, so that's fine. So if we're looking at the closing submissions and the case summaries being aligned in timescale, my initial thoughts were to work on successive Fridays. So 2 Fridays on, 14 days on from tomorrow would be the deadline for the closing submissions and case summaries from all parties other than the applicant. And then a further 2 weeks on from that would be the closing submissions from the applicant as a right of reply. Is everybody content with that timescale? I should have actually opened up my diary. So
I'm very thought of being is it a week or 2 weeks after you were thinking for the applicant. The only difficulty is that, and I think Mr. Finley as well, we have an inquiry up in Highland on the 21st of March, which will very fully occupy us for a few happy days. I don't think it's a long inquiry. I think it's a 2 or 3 day inquiry. If we could allow at least a week after that until my submissions are due, that would be helpful to me.
Can I add something? I wasn't quite probably paying full enough attention, although I was wide awake during yesterday's session. But I think there was an exchange of documents to come in yesterday, which pursuant to the Wildcat session, and obviously Susan Shaw is going to need to see those before that needs to be complete before she puts her final submissions in. And also, I'm mostly on holiday for the next 2 weeks, so I was going to suggest that the council submissions by the 25th of March, which I think is 3 weeks on Friday, and Mr. Trinick's submissions by the 1st of April, with no illusions intended as to the what he's going to produce on the morning of the 1st of April. That's my suggestion to that. But for that, and that would allow both of us. Mr. Trinick has had a harder task at Kirkham than I do because he's presenting it. I'm just opposing it.
Obviously, I'm conscious that there is other business for you to attend to. We were affected by it at the start of this discussions at our pre-examination, if you remember, and the timing of that particular inquiry. I don't have a strong view on that. The 3 weeks and then a further week. Does that helpful to you, Mr. Trinick?
Yes, ma'am. I think it's going to have to be. I have done. Yes, I can do that.
I'm assuming, Ms. Shaw, you would be content with that. It's giving you extra time as well. So, so I'll write that down and say it out loud. So that's the 25th, Friday, 25th of March, for the closing submissions from all parties except the applicant. And then the 1st of April for the applicant's submissions thereafter. And that the case summaries would align with those dates. So that will all be connected. Thank you very much. That's very helpful. And the second point is the issue of expenses. And apologies for you catching us unaware yesterday. Ms. Shaw, I should have known about the expenses procedure, but it is very rare in Section 36 cases, so I hadn't actually reviewed the legislative context for it before the start of the event. But I do have some information for you, which I think will clarify the position. Certainly, there is provision for expenses in the course of a Section 36 inquiry, and it's not provided for in the actual Electricity Act. It's provided for in the Local Government Scotland Act 1973, Section 210. I've also confirmed from our own internal arrangements that in practice, we would apply Circular 6 of 1990, which is aimed at planning appeals and the criteria that would apply for the award of expenses. The Act itself, the 1970 Act, doesn't provide a test or indicate on what basis the ministers could award expenses. Therefore, it's a matter of practice rather than regulation that we would use the planning guidance or the planning circular. There is a matter, so if we were to apply that approach, we would expect the claim for expenses to be in before the end of the inquiry or hearing session. Now, I would take from that by indicating yesterday that you intended to submit that the claim for expenses, that met the requirements in brief. But I would, however, expect it to be followed up by written submissions, as I'm sure the applicant would as well, and you'll appreciate that the applicant has a right to respond to matters raised. I'm looking to align those timescales with the closing submissions for the purposes that it just means there's a clear timescale set. Does anybody have another view on that? Mr. Trinity?
Yeah, I said yes to the 1st of April, forgetting about the expenses. I think if we have a dealing with expenses as well, and you want the closing submissions to align with the response to the application, then I'm going to ask for the 8th of April.
Okay. So you would want 2 weeks after if you want them to align. Would you be bearing in mind that Mr. Finley's interest, I'm assuming, are not particularly just on the expenses. We haven't seen the expenses claim, but that they are likely to be, from the impression I got yesterday, to be a matter for the applicant. Would bringing the expenses claim forward be of assistance to you so that it's sat on a 2-week deadline and then?
Not really.
No.
I'd rather keep aligned and ask for the 8th of April.
Right, okay.
And by the way, just for the record, we agree that the Local Government Act Scotland 73 does provide the necessary ability to make an application for expenses.
Yeah. So we'll change that. I have to go back on that. So that's the 8th of April, and then we'll deal with the expenses separately, but using the same timescales.
Yeah.
Now, just to make it clear, in terms of that, I would expect that the documents would be completely separate. They would be unrelated to one another in terms of their submission. We're just looking at aligning the timescales. We're not looking at aligning the actual submission. I really would want to make sure that the claim for expenses and the applicant's response are not directly confused with the statements of case or the closing submissions. So as long as we're agreed on that. So that allows us to proceed. Is everybody content that we've addressed the issue of expenses and how to move forward with that? Ms. Shaw?
Yes, that's very helpful, ma'am. Obviously, I should have referred yesterday to the provision of that within the code of practice as well, I think, which is quite a useful summary of the position. So apologies, I didn't have that to hand yesterday.
Apologies, I should have known as well, and I hadn't looked, and because I wasn't prepared for it, I didn't have the information handy. So with those two bits of business addressed, I'd really like to move on to the hearing session itself now.
Just one more matter before that.
Yeah.
We have a conditions hearing session later today. The further progress, as I'm told, being made between the council and the applicant, and you will be sent a further version of the conditions, but it will be track change, so you can see what has changed. You won't have to read a new clean version.
Right, bear with me just a second, because there was things popping up on my screen as I was speaking. Right. Okay, so I've got, yes, very first thing this morning, I received a track change version of the combined conditions, which was previously 10.6, so it's a replacement version. I need to check. Ms. Shaw, did you see that this morning?
Yes, I confirm that we've received that. Thanks. I noted the point that was made there about the ecological corridors and changes to things to condition 24. So.
Detail, but it may have a bearing on your own interests here. So I have that, that's fine, and I have the track change version, so as long as there's nothing further comes in, it will be difficult for me now to kind of take on board anything else that you're busy working on, and I'm sure it'll be difficult for you too, so we might just have to work from that point forward, because I really don't think there's anything likely to change now, and it'll all have to happen post our hearing. But thank you for that. I also got through an email from, I think it's coming through from Kirsty Smith, a direct copy to core document 430. I know it's picky, but I would really prefer everybody to open at 430 from the original location, unless you were able to confirm, Mr. Trinnick, there's something different about the 430 that was in the email.
There's not. If you go to, I'll do it right now. You go to 430, within 430, there is a link, and that link takes you, hang on, let me close this thing a minute. Bear with me. The link is in 430. It takes you to the document I want to refer to. My only problem is, having opened that document, it assumes I want to go to it every time, so I have to start up at 430.
Okay, no, that's fine.
Okay, it's my technical problem. Yes, I've now got 430 itself, and there's a link which is called Scottish Government website. If you press that link, and you can then open the document which has got the information in it.
Okay, that's fine. Yeah, I think that's working fine for me. That's okay. I just wanted to check it wasn't different, because obviously there's a difficulty of suddenly using the email version at the last minute. Sure. There's Mr. Hammack appearing on screen, so that's timing is quite good for the start of the hearing session. Okay, so we're going to now move on to just the hearing session, which is hearing session 1 on policy matters. And I've issued an agenda for that. I'm assuming everybody has that in front of them. I'm going to be following it roughly, although my questions might not be exactly verbatim to the ones that are put in the agenda items. The purpose was to alert you to where the discussion would be. I'm going to lead a structured discussion following the topics set out in the agenda, and my questions will be addressed to the main contact for each party, and then you can decide as to who's best to answer the point. Other parties are also going to be an opportunity to contribute or respond to the matters raised. So I might ask the question of, say, the applicant or the council, but I will give the other parties that are here an opportunity to participate on that point. If you have nothing to add, please just shake your head. There's no need to turn on the microphone to say nothing. So just shake your head if you don't wish to add anything on those particular points. If you do want to raise a question through the discussions, please just raise your hand. But obviously I won't let you interrupt someone that's speaking, and please don't speak across them. The whole idea is that people are given an opportunity to make their point, and then we'll allow everybody their chance to respond. So please don't interrupt, even though you fundamentally disagree with something that's being said. Please don't interrupt the person's flow. Now, is everybody clear about these procedures? Do they understand how that's going to work? Not seeing anybody raising any concerns, so that's fine. Obviously, there's some core documents that we're most likely to look at today. I'd expect you to already have perhaps hearing statements open and available to look at, or printed out, whichever suits you. We're obviously bearing in mind the agenda items. We're likely to be looking at Scottish planning policy. That's core document 3.1. And I would highlight to you that the applicant spotted that they'd given us the out of date, or the superseded version from 2020 that was rescinded, and that you should be looking at the 2014 version, and that was circulated just before the start of the inquiry week. We'll be looking at NPF 3, which is core document 3.2, draft NPF 4, which is core document 3.3. We're likely to look briefly at the strategic development plan from 2020, that's core document 3.4, the local development plan 3.5, and some bits of the council's guidance core document 3.8 and 3.9. That doesn't preclude you from raising or drawing to my attention other items. Some of the other policy and guidance documents relating to energy targets, there's quite a lot of them, so I wasn't going to pinpoint one as being something we're going to look at, but I thought it was useful to have the main policy documents ready for when we reach that point. I have a question. I got an email. That email that's just coming through before I started was what Mr. Finlay referred to as the update on Mr. Hewitt's qualifications. But I do have a question of just process for Mr. Finlay. The hearing statement from the council is written in the first person, and the views appear to be Elizabeth Tully's because it starts with her introduction. I suppose I'm looking for some kind of a position from Mr. Hewitt on the positions set out in that hearing statement. Are you able to address that?
Yes, Mr. Hewitt and Ms. Tully are similar standing, and indeed Mr. Hewitt was involved. The Aberdeenshire have had two planning inquiries, this being the second, the first being a wind farm called Fetteresso, where Mr. Hewitt gave the evidence. So Ms. Tully wasn't available to prepare, so Mr. Hewitt is adopting her statement. He's read through her statement, and he's, as I understand it, happy to adopt it as his evidence. And he will be able to speak to it. And if you wish him to make that clear himself, he will do so. But that's his position. And indeed, for those who haven't had the chance to open that email, perhaps he is a member of the Royal Town Planning Institute. He is a MA degree in Geography and Spatial Planning from Aberdeen. He's been working with the Strategic Delivery Team since 2017, and his workload focuses primarily on national and major applications, including those submitted under the Electricity Act 1989. So this is definitely as well qualified as Elizabeth Tully to speak on policy matters for you this morning.
Thank you. That's fine. I just thought it'd be useful to clarify for the record how that exchange was happening. So that takes us to the first item on the agenda, which is technically item 2, and that's dealing with the matter of UK and Scottish energy policy context. I really wanted to give everyone that's interested in this particular part of policy matters an opportunity to draw out just the key parts of the policy and guidance that they would rely on in terms of the importance that should be placed on energy policy matters, and also the role that onshore wind energy might play within meeting the relevant greenhouse gas or renewable energy targets. So I'm looking at key points. I really want to give you a chance to hone in on what you consider to be the important points of those documents. I'm aware that the council and the applicant have agreed the list of relevant policy documents and guidance documents on energy policy matters, but I'm still looking at giving you the opportunity to respond to that. So we'll start with the applicant and his witness as to how they wish to respond on those 2 points.
Thank you, ma'am. I'm dealing with this particular item. It's about the only one I am, but I will lead on this. What I haven't done is to start to pick out documents that Alison Sidgwick has listed very thoroughly in her hearing statement and elsewhere. That would be to repeat what's there. My take is that this agenda item is about policy, but you cannot divorce policy from law in this discussion. The law set out in my legal submission, CD 86 on net zero, was the product of and certainly reflected a vast body of earlier policy reports. For example, the IPCC assessment reports, but many others. And in turn, the law as it now is, and which I've set out, has been followed by numerous further reports, white papers, policy, and those 2 are set out in Alison Sidgwick CD 11.4. For example, but only for example, the IPCC 6th report of 2021, the UN Gap Emissions Report of 2021, the Energy White Paper, Powering Our Net Zero Future 2020, the Scottish Government's Programme for Government, and so it goes on. It's all in the statement. Now, the link between law and planning is now very clear. I said that in my legal submissions, but in summary, sections 3A and 3ZA of the 1997 Act, Country Planning Scotland Act 97, and both of these sections were inserted as recently as 2019 by the Planning Scotland Act 2019. And they require, first of all, they require the new NPF, which is to be NPF 4, as it's going to be part of the development plan. And they require the national outcomes to be addressed in NPF 4. And I've set out the national outcomes, the source of them in my legal submissions. I needn't drive back to that. But one of those national outcomes is including legal net zero targets. And so NPF4 is to be the policy instrument to drive net zero. And thus, for once and at last, thanks to the 2019 Act, the link between law and UK and Scottish energy policy and planning policy is now visible and complete. Pathway is clear. Now, if we look at what's happening, if we please turn to Alison Sidgwick's hearing statement, which is CD 11.3, at pages, I think they are in the electronic and real, page 13 and 14. Paragraph 428. It sets out the yearly interim net zero targets, ending at the top of page 14 with 2030 at 75%. So, bearing that in mind, if we do go but we don't have to go to CD 30 immediately and so see if we can avoid it, because it's going to be easier. If we go to CD 11.3, which is, 11.4, the supporting document for Alison Sidgwick's hearing statement, and within that, if we go to paragraph 321, which was paginated or not, but if you can find paragraph 321, wait till you're there, man.
Yep, got that.
And the heading is progress against greenhouse gas emission targets. So the progress towards net zero targets for the years available. The targets, the interim and final target shown in figure 5.2. Source is Scottish greenhouse gas emissions 2019, which is CD 430.
Ah, right. Yeah, the connection.
Is the source for that. And the 2019 figures are, believe it or not, the latest available. They were published in 2021. We don't have the report for 2020 yet. And if we go to that figure 5.2 over the page, it shows in columns what's been achieved. But more importantly, are the paragraphs which follow. More important, the paragraphs which follow. The targets are being missed. In 2018, 50% against 54%. In 2019, 51.5% against 55%. The 324 makes it clear that Scotland hasn't done enough to reach what is required to meet the overall net zero target. More needs to be done. And the last sentence is particularly important, that the targets, as they ramp up, will become more and more challenging to meet if the early targets are not fulfilled. And then I think perhaps we do need to go to that link within CD 430, if you wouldn't mind.
I have opened something, it's just 3 pages, is that correct? It's just a digital. It's headed up Scottish Greenhouse Gas Emissions 2019, published 15th of June 2021.
It should be a lot more than 3 pages. Not you.
Right, okay. So that's what I was trying to, because that's what came through on the core document list.
See.
Right.
Well, yes. So let me close that down just a moment, because I think there is a way. Let me just go back to the start. CD 430. You open 430, and you scroll down until you.
And it says full statistical publication on Scottish Government website.
Yeah, but there is a link to get to it.
Yeah, it's a hyperlink on the
Yes,
website.
To get to that.
Okay. It's always a difficulty of hyperlinks within evidence is a bit tricky as to how we approach it.
But it seemed to drop my link. Look, I tell you what, forget it. It's dropped my link now anyway. It's getting too complicated. Leave it.
It is summarised underneath, and it does state the outcomes. So it's giving you the summary that you want to highlight.
The summary I highlighted, but what it doesn't, what Alison Sidgwick's evidence doesn't do, and what that document does do, is track back to 2016. And the fact is that from between 2016 and 2019, 4 years, the emissions reductions was 49% to 51.5%. So that's a 2.5% achievement. However, that equates to about 0.6% per year. You think that we've got 12 years between now and 2030. 12.6 is a 72, an extra 7.2% on top of 51.5%. You're still short of 60% and very well short of 75%, which is the point made by Alison Sidgwick in her document. As they ramp up, the targets will become more and more challenging to meet if we don't keep up with the yearly targets. And thus, ma'am, the importance of UK and Scottish energy policy, referring to the headline of your agenda, policy and laws, every contribution to the legally binding net zero targets is vital. Of course, that does not mean that every renewables project must get consent. But in my view, the need to achieve the net zero targets is such that And I think this is a critical point for your report. I suggest the application of the planning balance is necessarily effective. If you view the planning balance as a continuum between no and yes, or you would view it as a set of scales with weights on each side, then in my view, the amount of harm which is needed to justify a refusal of consent is now, noting the figures to which I've just referred in the legal obligations, greater in each case, each project, than would be so without the need case represented by energy policy and by the net zero legal obligations. I don't want people to start saying, oh, Mr. Trinnick is saying that every project must get consent. It's just you're whitewashing all the other issues. I'm not saying that. There will be bad projects coming forward and they should be refused. But each project needs to be approached in the way which I've outlined. I think the planning balance has shifted along that scale. And looking finally at timing, 2021 is awfully close to 2030. If we look at Alison Sidgwick's report at paragraph 515, which is on page 16, we can see the gestation period with or without an inquiry for projects, and that isn't just made up. That is based on DPEA published timescales in the case of inquiries. That's been factored in. Otherwise, that table is built on development experience of how long it takes to get from A to B. So the fact is that unless a project gets started around about 2023, and assuming it's going to have an inquiry, even something starting in 2023 is going to struggle to meet 2030 targets. For SOMAM, the need for renewable energy and onshore wind energy is very great and it's very urgent. That's the importance of policy. But do you want me to go on to deal with the second part, onshore wind? It's very brief, and then I stop, or do you want me to stop there?
Yes, please, just to look at the onshore component of that, yeah.
Well, this development, ma'am, can generate by 2025, and so it can help meet the shorter term net zero targets. In terms of the references, I'm going to give you the references as to the importance of onshore wind. CD44, which is the onshore wind policy statement, not the draft, issued 1 of 2017, some energy electronic page 3. And if you bear with me, I think I may have something helpful there. Let's leave it as a reference. I don't want to take up too much time. If you go to CD 442, which is the onshore wind policy statement refresh, ministerial forward, you'll see more said there about why onshore wind continues to be important. If you go to the OWS refresh, at paragraph 211, you get more on the topic. I'll let you read that. I'm not going to post it to the inquiry. It is clear in summary that onshore wind does have a major role to play in achieving net zero targets. This development of well over 50 megawatts of new power, we don't know how many megawatts yet, it depends on the turbine chosen, but it's a large development, will make a very valuable contribution to net zero. I'm sure people will say, drop in the ocean. Good luck with that. They'll say there are plenty more projects out there. My answer is, we actually need every single contribution that gets consent. Every single contribution helps towards net zero targets. And secondly, new projects are needed now, not when something apparently better comes along, because from experience, it just doesn't. you push the problem down the road. We have a project which is acceptable, which can contribute within the relevant timeframes, and it is important for that reason. Thank you, Mel.
Right. Does the council wish to present something of similar nature to do with the UK energy policy and onshore wind?
Probably not of a similar nature, but
Yes, please.
it's going to be a two-pronged attack. I'm going to say some brief points first, and then Mr. Hewitt is going to follow. Both Mr. Trinick and I have made legal submissions, and I'm not sure either of them are core documents, and it may be sensible that they are, so that we can refer to them in our closing submissions, and that's something that can no doubt be done by agreement. Our position is set out in those legal submissions. I'm not going to attempt to respond to Mr. Trinick in detail. We'll have the benefit of the recording to look over, and I can provide, insofar as it is necessary to do so, in a more detailed response in our closing submissions. I simply note the statement of agreed matters which is CD 10.1 at 8.9, and at 8.10 it is agreed that great weight should be afforded to the benefits of the development, taking into account the up-to-date renewable energy policy framework. That is an agreed position. In brief, we say Mr. Trinick overstates matters, and that's all I wish to say. I'll pass over to Mr. Hewitt now.
Thank you. Yes, and again, I don't plan on really going into extensive detail. A lot of it's already covered in our hearing statement and views on their documents. However, I would suggest that energy policy and climate change policy at a national level is absolutely relevant, absolutely important in determining an application of this nature. However, it does not include an express spatial dimension insofar as directing where development should occur. And we are starting to see that be picked up in documents such as the onshore wind policy statement refresh, where there's references to the land strategy within that document, which makes reference to development in appropriate locations. But in order to fully understand and to fully assess the impacts of the development on the ground, you absolutely need to rely on a combination of energy policy and planning policy to get a complete picture. And again, that brings back to the balancing exercise that Mr. Trinick has spoken about already this morning. But the second point I would make there is that to an extent, climate policy and energy policy and the goals associated with that are already consideration within a planning exercise. Yes, the direction of travel is increasingly putting them in a more express way. But in undertaking a balancing exercise, we would need to be very careful not to double count these goals or these aims insofar as they're included within planning legislation, within planning policy, and also within energy policy at this stage.
Yes, thank you. That's all we wish to say by way of response at this stage. I think we could both keep the hearing session going on energy policy all day if we wanted to, but we restricted ourselves to those points.
I was looking for key points, so thank you for that. Now, Mr. Hammack, you're there. Do you have anything you wish to contribute just on this issue of UK energy policy?
I'd just like to point out that I think Mr. Trinick's a little conflicted in the sense that he says that great weight must be given to UK energy policy such that perhaps it outweighs planning considerations, but then he also admits that some projects should not go ahead because they'd be, to use what he describes as a trite phrase, in the right place, in the right time. Some will be in the wrong place and on the wrong scale. So I think there's a little bit of cognitive dissonance going on there. That's my only comment.
Ms. Shaw, do you have anything on that matter?
Yes, just a couple of points. I think that we've hopefully covered this in some detail in our hearing statement, so I don't want to rehearse everything, but I think in short, there's not a disagreement about the importance of renewables. There's no disagreement in terms of the importance of UK energy policy, but it has to be clear that UK energy policy doesn't sit aside from or apart from other equally important international commitments, in particular in relation to the IPBES report, which has obviously highlighted that we're in an ecological crisis. The climate crisis is a part of that, of course, but it doesn't sit apart. And our concerns obviously relate to Scottish wildcat. It's an apex predator, and for that reason plays a particularly important ecosystem function. So I think it's important that we also look at the commitments that Scottish ministers have made by reference to the Environment Strategy 2020. And I just want to draw out for the purposes just now that the overriding aim of that is to create an overarching framework for Scotland's existing environmental strategies and plans, including the climate change plan. And that obviously sets out the importance of taking into account key environmental considerations as part of that. Let me just see. So I think overall, we feel that the applicant has slightly skewed the balance there. And whilst there is no doubt that onshore wind continues to provide a very important contribution to renewables targets, it has to be noted that renewables considerations also relate to things like energy efficiency, demand response, developments in innovation and technology, which are also going to be extremely important to achieving Scotland's targets. So here, I think in summary, we're looking at potentially 0.01% of generation capacity, and we don't think that that justifies the harm that would be associated with this development as far as the wildcat's concerned. I think if I can turn then on to the onshore wind statement 2017, just bear with me a second. So that's CD 4.4, obviously, it itself recognises that we must support developments in the right place and of the need for case-by-case assessment of that, and highlights that achieving appropriate environmental protection means that the relevant planning and consenting processes must remain aligned with the policy context and the desired outcomes. We've obviously referred as well to the 2021 refresh, which is still a consultation stage. That obviously we don't suggest attracts significant weight, but we've referred to it basically to say that we're continuing on that existing direction and that it further cements existing policy requirements. So I think that's the main points that I would wish to add for just now.
Is there anybody wishing to add anything on the issue of UK energy policy?
Just a short, I've mentioned that the legal submissions should be core documents. In fact, they are. Mr. Trinick's are 15.9 and mine are 15.11, and Mr. Hammock's are 15.10.
Thank you, that's great, I've noted that. Mr. Trinick, do you wish to respond at all to these points before I move on?
The points all fairly made, and you've got them. I don't extend this into a debate.
That takes us to item 3, which is looking at the national planning context. Mr. Trinick's touched on it briefly, and it's the matter of the emerging National Planning Framework 4. Now, just as a matter of context, I know that until the framework is in place that we apply MPF 3. I'm conscious that this decision and possibly MPF 4, the decision might be in a similar time frame to perhaps the conclusion on MPF4. So I thought it was useful as an exercise to make sure people had an opportunity to set out for me what they think are the key differences in MPF4. And I'm going to look at that on 3 topics. I'm going to look at the issue of renewable energy and the policy context there, but I'm also going to ask a question on landscape and visual and ecology. So perhaps maybe deal with them in topic first, I think might be easier. So very briefly, energy policy, renewable energy policy first. Mr. Trinick, if you want to add anything from before.
I'm not quite with you. We were on item 3 now.
Yes, the national planning text.
It's the first bullet, the MPF, right? Not energy policy, but the draft MPF you want us to. Okay.
Yes, what I was saying is that it is evolving. MPF 3 is going to be replaced by MPF 4. We have a draft document. It's out for consultation. I just wanted to give parties an opportunity to draw to my attention what they think are the key changes. Yeah.
And that'll be Alison Sidgwick. I'll hand over to her. Thank you.
Morning, Mum. As you sort of rightly pointed out, the MPF is subject to consultation, and that consultation is ongoing, and it's widely expected that there will be changes to parts of the MPF as things go through, and I don't want to second guess what it may or may not say moving forward. But at a very basic level, MPF4 differs from MPF3 in 2 key ways. It incorporates Scottish planning policy, which is something that the previous MPFs haven't done, and will combine SPP and MPF into one single document, and it will form part of the statutory development plan, which is something that hasn't happened before. So it'll have a slightly different footing, as it were. As you're aware, it's subject to consultation, and I suspect there will be quite a lot of change to some parts of it, but perhaps not to other parts of it. And I think if I can look at it in terms of what I think may change and what I think may not change, sort of thinking about the differences as well as part of that, hopefully you'll find that helpful. Mr. Trinick's touched on sort of some of the key themes that come out in MPF4. And one of those is the climate change emergency and net zero, and the other is the nature crisis. And I don't believe that these key themes and focuses of MPF4 will change in the final version. I think we will see them playing key roles as part of that. The other part that I don't think will change significantly is the approach to national developments and the national spatial strategy. I think some of it may change a bit, but I don't think the general approach is likely to change. And as you'll be aware, MPF4 includes at National Development 12, Section 36 applications as being national developments. And the introductory text in respect of national developments on electronic page 44 is quite clear that they are significant developments of national importance that will help to deliver the spatial strategy. And I don't think that general thrust will change. And it goes on to say that the designation means that the principle of the development does not need to be agreed in the later consenting process. And again, I don't really expect that to change. And in the context of renewable energy, that's the sort of, in my mind, that's the general needs case that sits around renewable energy development as a whole. And I think that in considering these elements that are unlikely to change or unlikely to change significantly, that some weight could be attached in decision making to them. But I think that there are elements that will change, and I think that you can attach less weight to them. Now, as you'll be aware, MPF3 and SPP didn't contain development control policies as such. And that's a key difference. And I expect that some of these policies will change. There's a lot of discussion and debate going around in many different environments in respect of the policies, the way they're worded, and the consequences that they would have on development. And there's also political interest in it. And I would expect that there will be changes to the policies. In terms of the key policies that I think are relevant to Clashindarroch 2, I think policy 2, which is the climate emergency policy, is a key policy. And I think that policy 19, which is the green energy policy, is also a key policy. But there are also other policies that have relevance. And within that, I'd include policy 3, which is the nature crisis policy. And in particular, parts C and D of that policy, I think, are important. But exactly how they end up in the final version, I don't know, and I wouldn't wish to speculate on. And I think policy 32, natural places, is also one that will have relevance. And as I say, I think the policies, the wording of the policies, the nuances of the policies, it is much more difficult to attach weight to in a decision-making process at the current time, in the knowledge that consultation is ongoing. And in my mind, those are the key differences, and I've tried to put them into sort of two categories, which I hope is of assistance.
No, that's very helpful. Yeah, that was exactly what I was looking for, just as a pointer from your own point of view. Does the council wish to come in on this point?
I'll ask Mr. Hewitt to respond.
Thank you. I think from the council's position, looking at the draft NPF4 in terms of the relevant policies, the relevant aspects, within the wider document, there isn't a significant change of approach when it comes to how we assess, how we look at developments of this nature, insofar as it's still seeking to achieve the right development in the right place. So the planning balancing exercise is still actually fundamental within this. And indeed, we are seeing climate change, climate emergency, and biodiversity crisis explicitly folded in within NPF4, and we're seeing those as universal policies within the document, which should apply to all developments. However, I think it's important to highlight that the other universal policies do also include matters such as those related to placemaking, those related to human rights and equality, and the plan-led approach. So there isn't a suggestion within the document that climate change or the climate crisis takes precedence, or that it's first amongst equals. It is simply a consideration. It's an explicit consideration within the document. I believe that it's something that is already considered within the current regime that we are working under. And I would suggest that looking at policy 19, because that is probably going to be one of the more important ones within the document for us. Apologies, I'm getting the document open here. Looking at policy 19, the approach that's still being espoused within that is not similar to how we work at present. And there is a strong presumption in favour of development. There's a strong presumption in order to establish the principle of development on the basis that these are going to contribute towards combating climate change. However, Part K of that policy effectively recreates the list of SPP paragraph 169 and the list of criteria that we would assess against. And that really just underlined that, yes, while the principle of development may be established, it is still working under the presumption that you're carrying out a full assessment of the issues, and you're still considering all other issues when you're coming to your planning balance. So I think I definitely wouldn't quite say it's business as usual. There is obviously the emphasis there, but really the policy as a whole is does go beyond wind energy development as well, but it is clear that you're not looking at this matter in isolation. And I think the only other point that I would add is that the document should be read as a whole whenever you are applying it. I don't think that it's simple as you can say that something is in one place for a livable place. It needs to contribute balance towards all of it, and that kind of is almost emphasising what is SPP paragraph 20 written trying to seek the right development in the right place, not development at any cost. I think that would be all I have to say on it.
Does Sean want to come in on this?
And just a couple of brief points. I think some of these points have been covered quite comprehensively, and we obviously align with the position that's being adopted there by the council. There's no disagreement from us whatsoever in relation to the status of NPF4 at the moment. We see it as a continuation really of NPF3, but it's being more explicit about some of these obligations in light of the recognition now of the climate and ecological crisis being inextricably interlinked. I just want to highlight a couple of points from NPF4 which I think are of relevance, and they're set out in our hearing statement as well. But it just, again, on the emphasis for appropriate located developments, I think at page 6 it talks about securing positive effects for biodiversity, which is quite a direct statement. It talks about reversing biodiversity decline as a key priority at page 22 to 23. And then, as Alison Sidgwick has helpfully highlighted, it obviously at policy 3 refers to the nature crisis. We've listed there paragraphs A, B, C and D. So Alison Sidgwick has obviously referred to, for the applicant, policies B and C. On policy C, obviously, it's saying that effects should be minimised through careful planning and design, and that relates to some of the discussions that we had yesterday during the inquiry system, and of the need to reverse biodiversity loss. And then in terms of paragraph D, which hasn't been discussed, which is particularly relevant to this development, it says that development proposals for national major or EIA development should only be supported where it can be demonstrated that the proposal will conserve and enhance biodiversity, so they're demonstrably in a better state than without the intervention. And there's a couple of other points which are listed in our hearing statement, which I don't think that I need to go into further just now, but that's our key positions on it.
Thank you very much. Mr. Hammond, do you have a view on the NPF4 changes?
Madam, we speak of little else in Gartley. No, I don't.
Thank you. I realised obviously I was going to deal with this on topic basis. Ms. Shaw took us into the environmental and ecological matters that obviously are more interested from her client's point of view. Does the applicant, through Ms. Sidgwick, want to come back on those elements, or are they happy they've covered the questions I was going to raise about landscape visual policy or ecology? Are they satisfactorily covered in the points that were made? Muted, Ms. Sidgwick.
Apologies. I think they're covered in what we've discussed thus far, ma'am.
Does the council wish to come on issues of landscape or ecology?
Nothing more than what we've said already or is in our hearing statement.
That's fine. Thank you. That's really been really helpful. It's I say it's part of me thinking through how the balance might change as the months proceed through 2022. So that's been very helpful. It takes me on to the next point within the national planning context, which was about Scottish Planning Policy 2014 and sustainable development. Now, I think most parties have had a look at this issue of the sustainable development criteria that are in paragraph 29 of the document. Yeah, that open. Obviously quite early on. Pages. It starts at electronic page 13. So really I was just looking for, again, briefly, if possible, just to hone in on what the various parties think about the development and how it contributes to sustainable development in the context of the criteria, paragraph 29. What you would see as the key positives or failings, perhaps, depending on your point of view. Start with the applicant.
Thank you, ma'am. as you'll have picked up in my hearing statement at table 7.1 on our electronic page 25, I've been through the principles. And I think the key ones that support the proposed developments are the one at bullet point 1, which is giving due weight to net economic benefit. Bullet point number 6, which is supporting the delivery of infrastructure, for example, transport, education, energy, digital and water, and bullet 7, which is supporting the climate change mitigation adaptation, including taking account of flood risk and things. I'd go on to say that in order for a development to be considered as sustainable, it doesn't need to satisfy all of these principles. I think it'd be incredibly difficult for any development to satisfy tick all of the boxes and to satisfy them all. Also, sorry, I've missed off number 9, which is having. Sorry, 11, protecting and enhancing and promoting access to natural heritage, including green infrastructure, landscape, and the wider environment. And I think it's also important to have some consideration to the outcomes that are contained in SPP in the context of considering sustainability. And again, you'll find my view on that in the planning statement, and in particular, outcome 2 is covered at paragraph 139 at electronic page 29. And I think that's all I need to say on that.
And just to add to that, ma'am, that
apologies.
In case anyone wants to talk about paragraph 33 of SPP and the tilted balance, so anyone's mind at rest, we are not going to claim any tilted balance under paragraph 33. I think that could be because there's no development plan primacy when it comes to section 36, so it makes it quite hard to apply. In any event, the development plan is not really out of date. It's not even more than 5 years old, so I think we cannot claim a tilted balance, but we do claim the presumption. Thank you.
Mr. Finlay, on the council's view on these matters?
I deal with two overview points first and then hand over to Mr. Hewitt. It's essentially, first of all, to agree with Mr. Trinick that this is not a case or that the tilted balance should be applied, so which is probably a sigh of relief to everyone, that we can put that to one side. And secondly, to agree with Ms. Sidrick that whether something is sustainable development is it's not a tick box exercise. Paragraph 29, and I don't think there's a disagreement between the parties on this. It's an overall assessment which of a type which reporters have been making up until now and will no doubt continue to make. So it's the factors to be taken into account and a balancing exercise as to whether it's sustainable development. It's not sustainable per se. So really that's to record our agreement with the applicant on those 2 points, and I'll pass over to Mr. Hewitt to deal with perhaps the points of disagreement.
Thank you. I'm glad you've summed all that up rather than me. But yes, I think going through the relevant points, again, we would probably agree that giving due weight to economic benefit is important, but in saying that, if we with the caveat of looking at the nature of the economic benefit, for example, equipment is likely to be more associated with the construction phase, which on the grand scale of things is likely to be relatively short term. I would say that supporting good design and 6 qualities of successful places is perhaps an interesting one, and the 6 principles do more closely align to urban development than development of this sense. But if we look at it from the point of view of placemaking, obviously this is a location that has a sense of place, and that's something that we've heard through the inquiry sessions over the past few days, particularly within landscape and Bruce River and the importance to the community. So there's perhaps something to be pulled out there in terms of sense of place and placemaking. Obviously, it would support the delivery of infrastructure, as it is energy infrastructure, and it does have a role in climate change mitigation as renewable energy development. Within other points, having regard to the principles for sustainable land use is set out in the land use strategy. Now, I don't believe the land use strategy is listed as one of our core documents, but there is reference made to it within paragraph 4.21 of the onshore wind policy statement refresh, which is core document 4.42, I believe. And the extract that they have used within that document states that our land contributes to climate change mitigation in many ways. Scotland has a long positive history of harnessing renewable energy, and our capacity to generate it will need to be increased in order to meet our net zero targets. Our energy will continue to be provided by a wide and diverse range of renewable technologies, including onshore wind. We will need to continue to develop wind farms in the right places, and then it does fall from that. I think from that brief extract, accepting that it is an extract from contained within another document, does make clear that the principle of the right development in the right place is embedded within the land use strategy. So if we're looking at the land use strategy as part of the sustainable development exercise, probably quite crucial to consider that. And we would suggest protecting, enhancing, and promoting access to natural heritage does come into play, as does reducing waste, facilitating its management, and promoting resource recovery, and through the period, the waste generated in that, but also obviously depending upon the exact nature of restoration that's undertaken, whether, for example, concrete pads are retained in place, which obviously is usual practice these days. So that would be a long-term impact to consider. And then, of course, avoiding overdevelopment and protecting the amenity of new and existing development, and considering the implications on water, air, and soil quality. Because we are in a position where permission is granted for developments of this nature in perpetuity, which is covered within SPP paragraph 170. Yes, this particular development may have an operational lifespan of 30 years, but the use will effectively be established, subject to obviously further applications. Without getting the crystal ball out and trying to predict how technology will evolve and what those impacts will be, obviously there will be a change to the community associated with this particular development, and that can again change after the 30-year period. So there's obviously a lot in the mix when it comes to sustainable development. I've whittled on quite a lot there. But again, it's a balancing exercise, and I would agree with Ms. Sedgwick that it's all to be considered.
Thank you. Ms. Shaw, do you have a view on the SPP principles?
Not in terms of the principles, obviously, that the position of our client is that this is not sustainable development, but we agree with the framework and approach that has just been discussed and set out. Obviously, we seek to draw attention to the other points on environmental issues, which are also addressed there. And we also would draw, just as has been said, attention to the provisions about right development in the right place. Paragraph 28, the presumption in favour of sustainable development, such as renewable projects, is not to allow development at any cost. And paragraph 29, which includes environmental protection and enhancement. I note that paragraph 214 on protected species is marked down as a separate agenda point, so we can probably address that.
Yeah. Mr. Hammock, do you want to come in on these principles that are set out in SPP?
No, thank you. I think they've been well described.
Okay, thank you. That takes us to paragraph 214.
Just one point, man, to finish off that. I wasn't sure whether the council was saying that supporting good design and the 6 qualities of successful places was or wasn't relevant. We don't think it is.
Mr. Hugh, could you confirm why you mentioned it? It's just.
Yes, well, I suppose it was to highlight that while we accept that the 6 principles of successful places would be cumbersome to apply in this situation, the underlying with the the 6 qualities of successful places is to promote placemaking. And in terms of sustainable development, we do need to consider what the impact on place is, insofar as that is an impact that will occur.
So I think what we're just honing in on is that you're seeing that as a potential negative element of the sustainability criteria.
Yes, it could.
It's that.
Thank you, Madam. Just to record, we say that that's not so. Looking at outcome 1, which is what this comes from, that's all to do with urban development. It's not to do with this kind of development. That's our view.
Thank you. So we'll take on to the third point under the national planning context, and that's to do with paragraph 214. It's very specific. I'm not expecting to spend a lot of time on this. I'm just looking to confirm the party's position with the terminology of that paragraph. I'll get the right page. It's its own paragraph on electronic page 53. And it's about how the presence of protected species should be addressed. Clearly, obviously, there's an issue here that we've been looking at through the inquiry related to wildcat. So does the applicant wish to provide a position on that paragraph?
Certainly, ma'am. I'll do that. Clearly, it's material to this application. It's an easy acknowledgement. If there is evidence to suggest a protected species, that's wildcat, and other species on this site, which are recorded in the environmental statement, and then steps must be taken to establish their presence. We say we've done it, wildcat came and say we haven't. So there's a evidential matter for you to resolve, and we're not going to resolve it or try to resolve it in this discussion. However, protection afforded by legislation must be factored into the planning and design of the development. Any impacts must be fully considered. We say that through avoidance mitigation, both embedded and applied, and through compensation, establish the level of protection has been satisfactorily addressed through the EIAR, as recorded in the evidence of Mr. Bradshaw. Clearly, the Shaw will disagree. We're not going to reach a happy agreement at all, but that's where the debate is. And there are certain activities, and this will become relevant when we look at Aberdeenshire policy E1. So you might want to put down a marker that I will come back to this. Certain activities, those involving EPS, yes, well, that's wildcat, may only be undertaken under license. Well, that's not directly relevant to you now. You are considering the application for planning consent, not a license. So that, I think, is the relevance of SPP 14. Those are our views on the critical points. I know that the Shaw will take a different view. Thank you.
I'll just check. The council have a view on that.
We wouldn't have a terrible amount to add. I believe that paragraph 214 is fairly clear, and so much as seeking survey work to inform likely impacts and provide mitigation measures if required, which can be secured by a condition, and that ties in with the policy 1 of the Aberdeenshire Local Development Plan. So I think it's fairly straightforward.
Yeah,
the approach.
That's fine. We'll be coming back to conditions in a separate hearing, so we'll look at it more detail there. And Ms. Shaw.
Thank you very much. Obviously, not a huge amount to add to this, but just want to underscore from my client's perspective where the slight change in emphasis obviously is. People have talked there about mitigation, and we know the mitigation hierarchy starts from the point, as we discussed yesterday, of avoid. And I think it's important to set in context the reason why paragraph 214 exists within SPP, which is to avoid the potential of hostages to fortune, because we have made submissions that it will not be possible for the derogations that the applicant is seeking to ultimately be granted. And I would just emphasise that for that reason, in order to both ensure alignment with international obligations, and avoid the hostages to fortune point, that the provisions of paragraph 214 are very clear that the steps must be taken to establish the presence, and that this must be factored into the planning and design of the development, which is obviously subject of evidential points, and that any impacts must be fully considered prior to the determination of the application.
Right, thank you. Mr. Trinity, do you want to come back on anything there?
No, I think Michelle and I agree with what it says. We just disagree about how it's to be applied.
Okay, thank you. Mr. Hammack, I didn't introduce you there to that topic. Apologies. I was assuming you weren't interested in the wildcat directly.
I have a great interest in all these proceedings, Madam, thank you, but I have nothing useful to add to this discussion.
Oh, sorry, there's no value judgment as to your contribution. Right, that takes me to the next point, which takes us to the development plan. Now, the first point I'm raising here is a very quick one, and I'm going to ask the council primarily just to answer it, and it's to do with the two spatial frameworks that exist. One sits within the comparatively new strategic development plan from 2020 and the slightly older local development plan for 2017. Clearly one in theory is newer than the other, but I'm trying to establish if there are any differences. The plans are small scale, and I'm looking for confirmation as to the relevance of whether they're identical or whether one supersedes the other.
Mr. Hewitt will deal with this one.
Thank you, ma'am. The two maps functionally show the same information. I would say that the most significant difference between them is if you are looking at the map within the local development plan, there are areas, orange hatching, which show areas of strategic landscape capacity for wind turbine development, whereas the strategic development plan does not. But if you look at where the information has come from in order to inform these plans in terms of the groupings, they are functionally coming from the same place, with Group 1 areas being restricted to the National Park, Group 2 areas in light green in the SDP and in light grey on the LDP, effectively showing longer bubbles around settlements and nature restriction. The darker grey areas and the pink areas are respectively are other areas of protection coming from designation. So that will have been pulled from, for example, links from Nature Scott from designated sites and the likes of that. And I think where the LDP has went a step further is it has taken account of the strategic landscape capacity assessment in order to identify the areas with capacity. But I would just take this opportunity to reiterate how these maps are used, which is starting point in the assessment. When you see, for example, if you saw something that was a Group 2 area because it is dark grey in the LDP or pink in the SDP, you would then ask, why is it this? Is it for designation? What is the designation? What is the qualifying interest? And that would then feed into your wider assessment and be contained within the report. Hopefully that provides an explanation.
Yeah, I was really just trying to work out, because obviously it's important that I advise ministers as to which is the correct strategic framework, because one is newer than the other. But essentially, they are the same framework published in two different documents. And I accept the issue of the landscape capacity areas. That's a sort of separate mapping underlying the strategic framework. Does anybody have a view to add on that? It's really a factual question, but so please put your hand up if you do. I'm assuming that you don't. Right, okay, we'll just move on because that was a quick question. We've touched on the second point very briefly, the strategic landscape capacity assessment and its role as supplementary planning guidance or not. I think the council's evidence there just confirmed that it was a consideration. I think is where it's going, but maybe Ms. Sidgwick would want to just come in. We do have the benefit of the statement of agreed matters as to how we should consider the landscape capacity assessment, but perhaps, sorry, Mr. Trex disappeared off the screen, but if the applicant has a view on that.
Thank you, ma'am. Essentially, it's as set out in the statement of agreed matters. We don't believe that it is part of the statutory development plan, and it's not listed in the letter to Aberdeenshire Council confirming the adoption of the local development plan, which is contained at C 3.24. So the policy refers to it as being a consideration, and it is no more than that.
So the council agree that's how it should be viewed in their evidence?
Yes, ma'am. It's a consideration. It's expressly mentioned within policy C2 as a consideration. So I would suggest it's a consideration as a starting point. That is its status.
Thank you. Does anybody else want to come in on the issue of the Glasgow capacity matter? No, and that takes us on to particular policies, and that is the relationship between policy C2 and the local development plan. That's yeah, oh, so it's in different parts. Actually, that's what I've relied on my paper copies. Okay, so there's three policies that seem to be key in this, or four, I should say. C2 itself, which is dealing with renewable energy. E2 deals with landscape matters. E1 deals with natural heritage matters, and then the P4, which is to deal with polluting developments, counted land, and the issue of nuisance. I'm really looking at, it's something that came through in various documents, just really not looking at the policies in any detail, but just the relationship between these policies and whether or not when you have a renewable energy development that is clearly covered by C2, whether then you give greater priority to the policy considerations listed there, or whether the same, the matters listed in E2 and E1 and possibly P4 still remain equal to this E2 in terms of how we should apply them to the development in front of us. Maybe starting with the applicant on this.
I'll take this one if I may. Certainly, I think there is the concept of the lead policy. If there's a policy which deals directly with development being addressed, then that's where you start. And my approach, I will say it's magic in it, or it's legally preferable necessarily, but to look at that lead policy and then look at the other policies and ask yourself, do they add something which isn't present in the lead policy, which needs to be taken into account in addition? In which case, yes, that we better look at it and factor it in. In this case, C2 is all-encompassing in terms of the environmental impacts to be addressed, although fairly briefly. I think if we look at E1, so E2 rather, where it says we refuse development causes unacceptable effects through its design, locational design, or key natural heritage elements, I don't see any terrible conflict between that and C2. We might pick on the phrase key natural heritage elements, and the council might use that to point to Tappan off. I don't know. But I don't see as a great battle to resolve between C2 and E1 in respect. When it says that development shall otherwise significantly erode the characteristics of landscapes, or if that claim there shouldn't be any significant effects, then I think there is a bit of a conflict with, if not C2 in words, then with what happens inevitably with wind energy development, there will be significant adverse effects. as an inevitability of such development. So I would probably be tempted to give that part of E2 less weight. Otherwise, it's a harmless policy. It reads perfectly well with C2. I'll end up with E1 because that will take more time. Coming on to P4 then. I mean, there are only some small bits of P4 which bite here. There's the first sentence. We refuse development as a risk of cause significant pollution, significant nuisance or present. I can see how that can be relevant to noise. And the last sentence of that first paragraph, in any circumstances where development of this kind is considered acceptable, satisfactory steps must be taken to mitigate. Well, that's about conditions, and that's where we're going in the condition section. So in P4, I'll acknowledge a relevance, and probably it comes into play right alongside C2. So far as E1 is concerned, I do have more difficulties with it, but I have real difficulties with it. There's nothing on the first page which is relevant, because that's talking about designated sites of one kind or another. In fact, the relevance starts under the heading of protected species and continues into the first paragraph under wider biodiversity and geodiversity. You just bear with me.
Sure. Go out and closing submissions or doing a first round closing submissions on policy, which is on.
Spenny, I think you're not on mute. In case you're about to say something appalling. It's a very curious policy, this one, the protected species bit. And I note from the start that Section 25 of the Act is, of course, not engaged. So you can attribute really what weight you want to the policies. The text on European protected species, I think, confuses topics, because what's really being addressed there in planning terms is HRA, Habitat Regulation Assessment of European Sites. Concepts of OPI, imperative reasons of overriding public interest, and favourable conservation status certainly come into play when carrying out an appropriate assessment in the course of an HRA. But I don't see them as being helpfully relevant to the issue of European protected species. We have the law relating to such species in the Habitats Regulation Schedule 2 and elsewhere in the Habitats Regulations. And those regulations are to do with the creation of offences, not to do with making planning judgments. What I think has happened here is that, unfortunately, they've looked at the licensing requirements for EPS. And I've done that. And no, it's not before the inquiry, but it's Major Scott's guidance, standing advice for planning consultations on wildcat. But it also gives guidance for licensing. And it's under licensing applications that the concepts of overriding public interest, indeed no satisfactory alternative, and favourable conservation status come into play. I'm afraid the Council has got confused between licensing and planning in drafting this policy. I don't believe it's appropriate that you should have to look at overriding public interest or favourable conservation status in the context of any, it says, have a detrimental impact. Not a significant one, just any detrimental impact. That's going over the top, and it's inappropriate at the planning stage as opposed to the licensing stage. For that reason, I ask you to give this policy little weight. As to the heading wider biodiversity and geodiversity, it tells you that baseline survey has to be done. Well, we say we have, and Susan Shaw will doubtless say we haven't. And there we are. We're in disagreement on that point. But I think that's what I want to say about E31. So coming back to your question in the first place, which is the relationship between all the policies, certainly I think there's a good reason to, I think, E1 Doesn't add much to the picture, frankly. P4 does, and E1, well, I've given my views fairly pungently on E1. Thank you very much.
That's fine, thank you. Does the council want to come back on that at all in details?
I think it will deal with the detail in closing submissions, but Mr. Hewitt will add something brief now, just so you're aware of our position.
Yes, in terms of the relationship between policies, I would hesitate to suggest that policy C2 is the prime policy, simply from the point of view that the LDP should be applied in whole, and any policy that is relevant should be applied. But I do think that there is a relationship between various policies and C2 whenever you're assessing a development of this nature. I would point to the operative part of policy C2 being within the third paragraph of it, which states that all wind farms must be appropriately sited and designed and avoid unacceptable environmental impacts, taking into account various matters. And that is where we bring in the interplay of other policies. So in this case, that's where policy E1, E2, and P4, as you've identified, have come through. Now, in applying that, we would obviously have the presumption that we would like to have the presumption in favour of renewable development created through policy C2, but that is caveated with it considering all other impacts. So that then that would be whether or not it complies with the tests outlined in the other relevant policies. But I would say it's very important to note that the wording in C2 is avoid unacceptable impacts. So while something might not comply with other policies, there's an opportunity to carry out a balancing exercise there and to weigh up whether compliance with other policies is necessarily required. I mean, this might all be slightly involved whenever the LTP doesn't have primacy within an application of this nature, but I think it's quite important to try and keep the approach as close as possible as how we would assess this, given that if this had come in at 49.9 megawatts, it is why the council would have assessed it against this policy, and that consistency is important. Yes, I think that would probably be all we would say about how they're used and how they relate.
That's fine, thank you. Ms. Shaw, do you wish to come in on this point?
I think I can just cover it quite briefly. Obviously, we have a different position on this, but in relation to policy C2, as has been said, the key paragraph is that all wind farms must be appropriately sited and designed and avoid unacceptable environmental effect, taking into account the cumulative effect as well. So, I mean, I think ultimately the council would be required to properly apply policy where are we? E1? No, just give me a second, sorry.
E1 is the ecology one.
Yes. So our position is that policy E1 should have been applied, and I think that the key words in policy E1 refer to in all cases, impacts must be suitably mitigated before it comes on to talk about protected species. And again, just very clearly, this is a point of integration to ensure that there is proper compliance with the different obligations. So we can perhaps address it further in closing submissions if it's helpful.
Yeah, that's fine. Mr. Hammett, do you have a view on the development plan policies that we've been talking about?
No, thank you very much, Mum.
Mr. Trinick, do you want to come back on anything there?
No, thank you.
That's fine. And that takes me to something. Yes, that would take me to item 5 on the agenda, which is essentially the last point. And that's about a much older guidance document that's in the core documents, the use of wind energy in Aberdeenshire, 2005. It's not heavily relied upon, so I was really just wanting if anybody was able to tell me if there were any key elements of that we'd want to draw to my attention that were still relevant to what we have in front of us. A lot of it's guidance for practitioners and submissions, so just looking for key policy items that might have a bearing. Just I've opened it, so bear with me. It's in two parts, 3.8 and 3.9. Maybe start with the council, perhaps, might be in the best place to give us their view on what's still relevant here as their LDP and STP have moved on.
Mr. Hewitt will deal with this.
Thank you. On reviewing the committee report, it hadn't been referenced within that particular document, and to be quite frank, I would suggest it's probably not a document we as council would engage with for a development of this nature, given that it was written in 2005, and obviously, as we've heard in preceding days, things have moved on quite a lot since then, but I don't think I would have much to add beyond that.
No, that's fine, thank you. Does the applicant wish to add anything?
No, we would agree with that.
And do the other parties have a view on 2005 guidance? Which was here, Hammock, your hand up. You're still muted. Oh, there you are. No, you're muted again.
Am I okay now?
I said that's your through.
Right. Although this is, of course, an old policy, nevertheless contains some good sound guidance for developers. And I think one of the key ones is that turbines should not be sited on ridges or hills or where they will stand in the most prominent location against the skyline. Now, this was ignored in the original Clashindarroch 1 application, and it appears to be continuously ignored, sometimes by developers going for a 50-meter micro siting, and inevitably they seem to creep upwards. So I would just like to say that I think that was a very common sense and useful guideline, however old it might be, and it should be adhered to.
Okay, thank you. Let's see back on that. So, Mr. Trinick, do you want to come back to anything?
No, thank you. Good.
Ms. Shaw, did you want to add anything to that? No, that's fine. I've made some provision in the agenda just for any other relevant matters, and that was more in case of things that might come through the other inquiry sessions regarding policy matters that you'd want to draw to my attention. So I'll probably just give you that brief option. I say I'm not looking for a complete repeat of entire policy cases, just anything new or something that's come through from the most recent proceedings regarding policy you want to draw to my attention, and start with the applicant.
No, thank you, ma'am. Very sensible agenda. Tackle the main points. We can deal with the rest of closing submissions. Thank you very much.
Council wish to alert me to anything?
No, but just to raise one query, Mr. Hewitt did refer to the land use strategy by reference to a quotation in another document. It's something you may wish to have the document so you see the context of the quotation, and we could make that a core document if no one else objects. We're simply going to be referring to that passage that he referred to, but I think it may be helpful for you to have the context of it and in the broader document as a whole.
No, I think that's fine. Mr. Trinick's agreed to that as well. So it is a problem because it's a hyperlinked document in SPP, and it does often get overlooked because of that. In terms of its status, it's a separate document. I think that's fine to have that as a separate core document. Would be helpful. Thank you.
I'll ask Ms. Gibbs to circulate that this morning. Thank you very much.
Ms. Shaw, is there anything you want to draw to my attention? And Mr. Hammock, anything? You've just muted yourself, Mr. Hammock, again.
Right. Can you hear me now?
Yep, that's you.
I'm obviously not very technological. I'd just like to point to the shifting language which has been used to describe the need for this development. It's described in documents as important and significant, and this morning Mr. Trinick has described it as vital. I think we should stop torturing the English language and just look at the mathematics. The amount of energy this would contribute would actually be less than 1% of the current installed base. And of course, it's rapidly diminishing as the Scottish government figures show. So I would suggest that we should use, if we're going to use the words to describe it at all, as insignificant and unimportant and certainly not vital. And in conclusion, I'd like to thank you for your courtesy towards me this morning.
Thank you very much. Well, thank you for spending your time to join us and to follow the proceedings. It's useful to always have a different and local perspective on projects such as this. That's me coming to the close of the hearing session. I'm just checking there's no other procedural matters relating just to this hearing proceedings before we move on to hearing 2A. Now I'm going to need a little bit more time just because obviously I need to sort of change over a lot of documents and things I've been looking at just to review my notes. So I had, I think, tentatively thought we might start the second hearing at 11:30. We've got other witnesses that might be arriving from the applicant side. So those of you who are staying on just for this, just turn off your video and your microphone. You may want to join us after lunch if you're interested in the second hearing on the broader conditions beyond noise. So we'll leave this for 15 minutes. I think we might start at 11:45 if that's all right. And that gives me plenty of time to sort out my documents and make arrangements for the second hearing. And that will take us up to, hopefully take us up to lunchtime in the second hearing. Is everybody content with that 11:45?
Yes. Ma'am, can I just indicate that in the same way that Mr. Hewitt's qualifications hadn't found their way to you, neither had Lynn Farmer's, and we've circulated those. Again, I don't think it will come as a surprise to them, but it will just provide the basis for her qualifications and giving it.
Fine. So
take a note.
We'll see those parties that are interested in hearing session 2A. We'll see you at 11:45, and hopefully the other witnesses will have joined us by then as well. Thank you. Sorry, I'm not sure if you're listening, but I see Andy Mackenzie's waiting to be admitted to the meeting. Are you attending to that? Right. Well, it's 11:45. Is everybody back that needs to be here? I'm not seeing Lynn Farmer specifically. Mr. Finlay, is Farmer attending separately? I think you're on mute if you're speaking.
She should be on my right, perhaps your left as you're looking at the screen.
Okay.
On the picture that I have, there are now 5 of us in the room.
All right. I can still only see 4. So that unfortunately, I don't know if we can do anything about that.
Actually, should we move this table that way?
Yeah. So it's a problem for separation and things. Well, I'm seeing an elbow now, so at least I know you're there. Sorry.
Maintaining our separation.
Oh, I'm sorry. I've got to be seen to make sure that you do so as well. So,
No.
Right. Well, that's 11:45. Well, we're 11:46 now, according to the computer. So we'll start with hearing session 2A. There's some new people to introduce today at this time, so we'll maybe just do that. Perhaps just to introduce the additional people rather than to go back over everybody that was already here.
I'll let Dr. Mackenzie introduce himself.
Yeah, my name's Andy Mackenzie. I've been a consultant at Hayes Mackenzie, specialising in wind farm noise since 1991. I've got a degree in engineering acoustics and vibration from the Institute of Sound and Vibrational Research at Southampton University, and a PhD from the same organisation. I'm also a fellow of the Institute of Acoustics.
Thank you. And from the council, I think we have obviously mentioned Ms. Farmer already.
Yes, we have Ms. Farmer, who sits on my right, and hopefully you've got an email setting out her qualifications and experience. I'm grateful. On my left, slightly further to the left, is James Hewitt, and behind me, Ewan Brown, advocate, and Arlene Gibbs, who's instructing me.
Thank you. Excellent. We have Mr. Newman here still from this morning's session. So welcome, Mr. Newman. You have a specific interest in this and you've submitted a hearing statement about noise matters. So we'll introduce your evidence at the appropriate point, if that's all right.
Thank you.
Thank you very much. When we're not speaking, just to try and mute mics so that we're not getting any background noise. I know people are in the venue, so just be aware of that. So this is another hearing session. It's a discussion. It's me exploring topics and matters to help me understand where there's an area of dispute. But I just want to, for people watching rather than the participants, to confirm that it's a necessary part of my report to ministers that I prepare a set of proposed conditions to be attached to both the deemed planning permission and the section 36 consent, regardless of my recommendation as to whether those permissions should be granted. So for the purposes of this exercise, it's necessary to assume that consent would be granted, but you should not interpret that as an indication that I've already decided to make a favourable recommendation in this case. There's a separate agenda for this item, and I reissued it very quickly on Friday just because I thought we were going to have problems managing the condition numbers. So I reissued it with the updated condition numbers that reflected an updated set of conditions for document 10.6. Now, purposes of this hearing, I'm going to stick with 10.6 because I took a lot of my notes directly from that document. Dan, my understanding is that the updated document circulated this morning does not touch the relevant noise conditions or the guidance notes, and Mr. Trinick's nodding there, so I think that's the case. So it's suiting me just to stay with that because that's where I did my preparatory work, and I will take on board the other changes to conditions in the second hearing session this afternoon. It's likely we're going to touch on some obvious things. I'm sure you've already looked at that. So I'm going to be referring to 10.6. There is the review to do with amplitude modulation at CD 10.4, various hearing statements, X2 itself, the noise guidance, CD 12.6. There's the associated good practice guide at CD 12.7. And I think that's the key things that I'm likely to be looking at today or asking you to point me to the relevant parts. So I think, is there any other procedural matters to do with the set of conditions that you want to raise before we start? Oh, nobody's raising anything. So let's go to item 2, which is the first condition, which is 38. Now, this has been agreed, so apologies, I'm now investigating matters that the council and the applicant have agreed, but I really wanted to make sure I understood how it was going to work, really in relation to some policy considerations and just how it works in the context of the other 2 noise-related conditions. So, condition 38 is looking at the submission of the acoustic performance of turbines that have been selected to be constructed on site. So my first question really was, and you'll see it in the agenda, is there not a need for somebody to approve the report that's submitted? Because there's really only a requirement to hand it in. There's not really a requirement for anybody to agree that it's now meeting the noise levels, whichever noise levels they turn out to be. So can I have a view from the parties on that?
Yes, ma'am, we accept that there is a need for an approval of the document. And that can be built in. I'm sure we can draft it, you can draft it.
Yeah, but there should be some element of that. And I wanted to check as well, towards the end, the last phrase of the condition is talking about and on any curtailment of performance which may be required to enable compliance with condition 40. Now, I was really hoping to get an idea from the participants whether or not that is measures that you have already built in to the turbine selection or design that ensures compliance with the noise levels, or whether it is design features of these turbines that would allow you to achieve curtailment should there be a problem in the future. It's the use of the word may that was giving me a little bit of nervousness, and so I wasn't sure if these were things that were already built in or things that could be drawn upon at a later stage.
Based on the conditions which we propose and the types of turbine which have been assessed in the ES, there is no need for any curtailment of any of the turbines. If the turbine which is eventually installed at the site, which would need to comply with the relevant aspects of the planning application, but it is different in noise terms to what's been assessed for any reason, then there may be a requirement for curtailment, but that can be designed as and when that assessment procedure outlined in 38 Part 2 is carried out.
Right, so the reference to curtailment of performance is something that you're going to demonstrate in the choice of turbine and the noise thresholds. It's something that is already there when you submit the details of these turbines. You would have to specify that you've applied these curtailment of performance measures to reach that point. Is that correct?
That will be included in that report. If any curtailment was required for any reason, then what the curtailment would be specified in that assessment.
So I suppose if I was going to be strictly speaking correct, it would be any curtailment performance measures that have been incorporated to ensure compliance with. It's of a past tense, so it would be the details of curtailment performance that you have already embedded into your choice of turbine. And
Let me just read that slowly through what difference that would make.
it's about something that you've already built in.
Well, we haven't already built it in yet, but at the time of compiling that report,
Yes.
it would have been already, would be built in, yes, if that makes sense.
What items have been built in as part of the overall reporting and choice of turbine?
Yes.
So I understand what that is now, that's fine. So it's listing measures.
I just say we agree with both those points, both Mr. Trenick's point and Mr. Mackenzie's point.
Sorry, I hadn't to yell at that. Sorry. So part 2, it's a slightly different, it's actually technically a different condition in a way. So this is one now setting out that the turbines won't be operated until there's a scheme providing for the measurement of noise emitted at all turbines, with the objective of demonstrating compliance with the noise rating in condition 40. Now we're obviously going to come to condition 40 in a lot more detail, but I do need to ask, do all the turbines mean Clashindarroch 1 and Clashindarroch 2 for the purposes of this condition?
Yes, they do, ma'am. That they are 1 and 2. And there was a good point you made. We realised that we needed more words to make that clear. So obviously, we'll come on to discussing the cumulative condition more generally later. But assuming that this is what happens, then if you add the words emitted by all the wind turbines within the development and within the nearby development permitted on 8th of August 2012 under reference M/app/2009/1380. That makes it clear what we're talking about.
I think so. It's going to crop up, I think, in other parts of the conditions. So it'd be quite good, but if whatever wording we create for the combination Clashindarroch 1 and Clashindarroch 2, that perhaps that same wording is used throughout any combined conditions where there's a cumulative consideration taking place. So that's good. I've got to the bottom.
I just on that, man. I mean, in section 36, as opposed to TCPA conditions, that you can, of course, have terms defined at the end. You might make the condition less cumbersome if you simply define.
Yes, well, yeah, it could be
one or the other.
That we define Clashindarroch 1 and we define Clashindarroch 2, or words to that effect. We can work on that, and then we can use the shorthand version in the condition itself.
Indeed.
There's also an issue of definition in here, which I picked up on. I can find it. No, I think it's okay. I think it was the issue of dwellings near to the development, but I think that's been separate. Yeah, okay, that's fine. Yeah, that's covered that. So I think that's just a refinement of those conditions. I think everybody's agreed their purpose, and it moves us on to the more technical matter of condition 38. On 39, I should say, sorry, 39. I knew that would happen. So this deals with excess amplitude modulation. I'm going to call that AM because I think I'm going to get tongue-tied trying to keep saying that every time it crops up today. And there's obviously a disagreement between the council and the applicant as to how best to approach this. But I think it's quite positive here that it's agreed that a condition or some measurement device, some form of control is included as part of the set of conditions. So I was looking for a bit of explanation as to why it would sit out with the terms of condition 40 and the kind of more familiar terminology and guidance notes that goes with that. And and why it sits separate from ETSU, or does it? And so I suppose it's quite beneficial that we have Mackenzie with us. But I really would appreciate a little bit more explanation regarding the relationship of AM to ETSU and other more conventional noise conditions that have been used at wind farms.
We can consider noise as being able to be assessed in terms of its level. But traditionally, going back to probably as far as 1967, corrections have been applied, or corrections or penalties have been applied for things which we might want to call acoustic features, because they cause noise to be subjectively more annoying than just a steady noise level would be in the absence of such acoustic features. Now, the issue of tones is very well covered in ETSU R97. So they are routinely applied in planning conditions, and it's quite logical to apply a penalty at a wind speed where there's a particular tonal problem arises, because that through the operation of the turbines, that will inevitably almost be tied in with a particular rotational speed, meaning the gearbox has a resonance at that rotational speed, or something like that. Amplitude modulation, we can also consider that as an acoustic feature. Traditionally, because it's only really become apparent with wind turbine noise, it hasn't been an acoustic feature which has been assessed. More traditionally, acoustic features other than tones deal with things like intermittent noise or impulsive noise, if you will. But amplitude modulation has become an issue with wind turbine noise, because people such as Professor Newman have experienced it to be a particularly troublesome feature of wind turbine noise. However, the way that correction is applied for amplitude modulation is open to some debate. Some mechanisms have been put forward and adopted in some planning conditions, and what you see from the council in their guidance note 6, I think it is a way which has been proposed. But I find that way of assessing amplitude modulation to be too prescriptive, because it applies an averaging process, if you like, assuming that the same amplitude, that amplitude modulation, like tonal noise, is tied somehow to wind speed. Whereas I think it's more likely to be tied to specific atmospheric conditions or even specific wind directions. And as Professor Newman has pointed out, it can be to do with wind blowing through adjacent turbines, which would be tied in with wind conditions. So I believe that what we've put forward by way of a scheme to assess amplitude modulation takes into account the fact that it may be necessary not to penalise amplitude modulation, but to eliminate or indeed just minimise in some way amplitude modulation, so it doesn't occur with any kind of at a high level with any particular frequency, which is likely to be troublesome. In frequency, I mean not frequency as in the assessment of tones, but frequency as in how often it occurs. So I think that the scheme which we've put forward here allows for more flexibility than what's been put forward by the council. And just something which it might be worth looking at is the most recent decisions in Scotland on amplitude modulation. Now, the Arcleoc decision, which I think is the most recent one, doesn't include anything on amplitude modulation. But the decision on Paul's Hill 2 contains a condition which, not coincidentally, is very similar to what's been, or even the same as what's been proposed by ourselves for this one.
Ma'am, that is at CD 717.
Yes, apologies for that.
Yeah, no, that's fine. No, I was aware of the similarity with Paul's Hill. I did look at that beforehand. So this, just very briefly then, Is there any intention in condition 39 to apply this to Clashindarroch 1? I didn't see it, but I just wanted to check there was not that wasn't an intention.
Well, because the measurements are going to be carried out with reference to Clashindarroch 1 acting in, well, let's say the proposed development acting in combination with Clashindarroch 2, any measurements which allow an assessment of amplitude modulation would, by their very nature, apply to the combined effect of noise from both developments, which would mean that the council would then retain some control over amplitude modulation from Clashindarroch 1, but only through the planning consent on Clashindarroch 2.
Well, the reason for asking, obviously, if you're dealing with something that is perhaps turbine specific, like as you were explaining, there is a difficulty in asking for this condition to enter Clashindarroch 1, if you know, or the action from this proposal to enter in Clashindarroch 1 and sort an individual turbine, whereas noise levels can be addressed more generally, and that's why I'm kind of exploring whether or not this is how this would impact on Clashindarroch 1, or could, if it's actually possible to do that, if there was no amplitude modulation AM condition in Clashindarroch 1, whether or not that gives the difficulty if you were trying to achieve that.
I don't think it does, because it requires a scheme, and just for the avoidance of doubt, and I think this addresses one of Professor Newman's points, there's no intention that we will be looking at individual turbines. I'm not sure if when you said referred to turbine specific, I'm not sure if you mean turbine model specific, ma'am, or if you're referring to an individual turbine. Because yes, it may be turbine model specific, but any investigation wouldn't be into individual turbines. That would be for the operator of the site acting in conjunction with any noise consultant to determine the source of any problems arising. But the purpose of the condition is not to investigate noise from individual turbines, just from the development acting as a whole.
Right. No, that's fine. That's where it's just when you talked about things like gearbox noise or something that took me. That it might be something that's, because if it's mechanical, that it's got a direct relationship to one piece of infrastructure on the site rather than the overall effect of the turbine.
It will be model specific rather than turbine specific. Or if there was a fault identified with one particular turbine, which was, say, close to Professor Newman's house, then that would be targeted as part of any noise control measures.
And well, I need to introduce the council now. Obviously, I've heard Ms Mackenzie's views on that. So it's really just how they perceive this issue of AM and why a separate condition versus embodying the controls in condition 40 doesn't work for them.
Yeah. Thanks, ma'am. Yeah, I can't disagree with a lot of what Mr. Mackenzie says in relation to his description of amplitude modulation. But our main concern really is what happens if we cannot agree the scheme that is suggested in condition 39. We feel that we would prefer to be more precise. And we feel that our proposed condition within condition 40, guidance note 6, is a more clear and precise way of dealing with this, presenting the council's expectations up front, rather than leaving the approach to be agreed. If there's no agreement, there's no mechanism for you know, what happens if there is no agreement.
Right. So if I go to your guidance note, so it's 6, hence the guidance thing.
So you gave the, sorry?
Sorry?
You gave a reference there.
Well, it's It's in the guidance note 6 is in the 10.6, but it's quite far on towards the bottom of the document. It's in the middle column is guidance note 6, the council's version of the guidance.
Yeah. Cool.
So there's two elements to that. So and what you're choosing to do there in the council's version is to draw on a particular document which has been submitted as a core document, which has potential measurement approach, and that's what. And Mr. Mackenzie, your position is that could be superseded at any time. And it's presumably it's never been embedded into ETSU, this issue of EM.
The IOA metric, as it's referred to in this condition, is perfectly valid, and I think that will stand for a good many years. But it does say or any update to that method. The issue is that the value, it says the value of AM obtained within the IO metric for each 10-minute period shall be converted to a penalty in decibels in accordance with the graph below, and that's the bit that I think it's going to be subject to a review. The IOA methodology doesn't include a penalty scheme. That graph, I think, comes from the DEC Phase 2 report on amplitude modulation, which I think we sent to you as a core document. I'm not sure. I don't know if it is a core document, but I think Ms. Farmer and myself are in agreement that's where it comes from.
Right. So
sorry.
No, I'm just trying to get straight in my mind. So that it's the graph and the particular prescribed levels that are set out in the graph is the thing that might change, rather than the method that's set out in the IOA document.
Yeah, it's not even the graph that might change. It's this averaging process, because the Phase 2 report was very short on detail as to how the ratings of amplitude modulation would be converted into an overall penalty. What we've got in here is that they'll be averaged averaged by wind speed. So each wind speed would have an average AM penalty applied to it. Whereas because it's not a wind speed dependent factor, I don't think that averaging it by wind speed achieves very much.
Does the council want to come back on that point?
Perhaps if I.
Yeah, I just wanted to say, I think, yeah, I accept what Mr. Mackenzie's saying, in that the actual process, the averaging may still be up for debate, but if we're able to agree that a penalty needs to be applied if amplitude modulation occurs, then perhaps there's some way forward here, and we can agree the scheme of reaching that penalty, perhaps through a mechanism similar to condition 39.
Yes, if I can add that, I mean, even if one looks at the Paul's Hill condition, which is condition 25, it doesn't provide for what happens if the scheme is not approved. So there's no bite to the condition. Once it is approved, there is a bite to the condition, but there is no bite, and that's what the council is seeking. What I understand lies behind the council's condition was not necessarily being tied to the particular methodology, but was to ensure that there was something which provided bite to the condition. Now, Farmer's accepted Mr. Mackenzie's explanation, which is indeed clear and logical, but it leaves open the point I've just raised.
Okay, thank you. Mr. Newman's got his hand up. Mr. Newman? You're still muted, just yet.
Trying to unmute myself. Thank you. I find myself more in agreement with Ms. Mackenzie than with the council, because I can see that knowledge of amplitude modulation is a moving target and is improving greatly. I would draw your attention to the fact that in my submission, CT 14.3, I did include a proposed amendment to condition 39D to the effect that the scheme should be reapproved at the beginning of each biennial measurement period. And I think that basically this probably would help to remedy the possible deficiency to which Ms. Farmer is drawing attention. I drew this basically from suggestions by Dick Bowdler, which are incorporated in a published paper, to which I believe I think Ms. Farmer was a co-author, though I might be wrong. But anyway, I just wanted to flag that up at this point. Thank you.
No, thank you very much. Does anybody have a view on this idea of introducing a new methodology for EM at intervals throughout the lifetime of the planning permission?
I think, ma'am, what I'm going to ask for, because on this point of condition 39, is that you would give us 15 minutes just to adjourn and just discuss the matter and come back to you. It's difficult with the microphones on. We can't like any person inquiry where you can walk out.
No. Well, can I? Yeah. Before you do, can I just suggest something that was going through my mind is whether or not in the guidance notes where the methodology is specified, that guidance note 6, about how that guidance note could be used to provide flexibility in future methodologies. So if you're going to adjourn for a few minutes, maybe the council might like to look at that as well, and we'll come back in 15 minutes. That'd be helpful if I ask you to look at those two things. Right, so we'll switch off the mics and things for 15 minutes. And that's till, about 35. That's 12:35. Is everybody ready to come back yet?
Thank you for that, ma'am.
Yeah, there's the council. Mr. Newman's here. Okay, well, maybe over to you, Mr. Nick. Is there anything you can clear up for us from your discussions?
Yes, thank you very much. I mean, we do see the problem of enforcement. It's a good point. And as a consequence, we suggest the following. Against the background that while you can have a general scheme for the investor, how to investigate excess AM and control it, to some extent it is complaint specific. So you can't specify all the details necessarily in advance. Hence the 39 was written as it was, be responding to a complaint. But as I've said, we take the enforcement point. So what we suggest is that if 39 is amended to read, well, in fact, it's easier if you start by crossing out lines 1, 2, 3, 4, and the fifth one starting complainant's property, and to shall submit. So you cross out all those words. And in place, put the words, no wind turbine shall operate until, and then continue with the words a scheme. And after scheme, put is submitted to and approved in writing by the planning authority. You take that for the approval by the planning authority, and then continue with the rest of that condition. That's the first thing to do. There's a second suggestion, two more suggestions to make, but that is I think how you get around the initial enforcement problem, because Vattenfall could not operate the turbines until the scheme had been approved.
I'm a little bit confused because obviously there's no complaint triggering that if you remove the first.
I'll come on to that.
All right. Okay. Sorry. Right. Okay.
That's the initial condition, which gives an enforcement ability. You can't proceed until that scheme has been approved. If you move on to condition 40E, is addressing what happens in the event of a complaint. It starts the assessment of the rating level of noise emissions. If you put in there and any variation of the scheme approved under condition 39, required to take account of complaint-specific circumstances. And then you continue with the condition, shall be undertaken. So you've now got the initial condition, which gives you the enforcement, and condition 40E, which enables the scheme under section 39 to respond to complaint-specific circumstances. The third element is that if you accept all that, I don't think that we don't think that guidance note 6 or 7 are any longer required at all. Because what is necessary will be specified in the condition 39 scheme as may be varied under condition 40E. That is our proposal to get around the very real issue pointed out by the council. And obviously we wait and see what other people think of this.
Thank you. See, Mr. Newman's got his hand up, but Mr. Newman, is it all right if I ask the council's opinion first and I'll come back?
I do, of course, yes. Yes.
Mr. Trenick, what we can is clear from that is that Mr. Trenick and Mr. Mackenzie have clearly grappled with the problem. I think what we would like to see is it in writing and then to be able to respond, which we can do by way of our closing submissions. But I think I can make 2 points. Which Ms. Farmer has already alluded to, we're not wedded to the terminology, to the methodology in guidance note 6. We do recognise other methodologies will come along, and Mr. Trenick's formulation caters for that. And secondly, our concern, as we indicated, was enforcement, and that appears to provide for enforcement. We have nothing further to say at the moment, but we'd like to see it in writing. There's plenty of time in the process that's available for us to do that, and if needs be, there can be further discussion between the parties. If say that wording is supplied to us, it could presumably be supplied fairly swiftly. There's plenty of time for negotiation between the parties on this particular issue, as there has been between the parties on other conditions. So I think hopefully that's sufficient for current purposes.
Yeah, I suspect from the rest of our discussions, there might be other similar or revisions needed as we grapple with some of the discrepancies between the two sets of conditions. So I take that point. I think we'll come back to that when we've looked at some of the other issues that are still outstanding. Mr. Newman, your point.
I just would like to get some clarification. Is it now assumed that there will be a one-off approval of the scheme without any provision for it to be reviewed periodically in the light of developing knowledge?
Mr. Trinick, you can probably best answer that, seeing as it's your draft text.
Well, yes and no. So the initial scheme under condition 39 will follow best practice at the time it is submitted, whenever it is submitted. I mean, not at least 2 years from now, but anyway, whenever it is submitted. The condition 40 suggestion allows for variations of the approved scheme to take account of complaint-specific circumstances. I think implied within that is that the scheme that was actually submitted following a complaint would clearly reflect the state of current knowledge as well as complaint-specific circumstances. And after all, that scheme has to be approved by the planning authority, so there's the opportunity for them to review what is suggested in the light of then current knowledge.
Yes, Mr. Newman, sorry.
So does that mean that it's necessary, if one considers, as I think I do, that the biennial monitoring is an important feature that should be retained, is it necessary to make that case specifically, maybe in a concluding statement?
Well, how you want to make your case in concluding statements essentially is still up to you, Mr. Newman. I think we're going to come to the issue of biennial monitoring separately, so we've still got to discuss that. That's not gone yet because we've not got to that part of the agenda. So maybe leave that for now.
Thank you, ma'am.
Right, so the situation on these two conditions is evolving, on this condition is evolving, and how it might affect condition 40 that we're coming up to next. I'll add in one other observation, because it's very minor, that nobody gave a reason for condition 39, and you might want to have a think about that when you're redrafting. I think that's, so it's still there in the mix. So it takes us to condition 40 in the agenda, which is item 4. And I've got quite a lot of issues with that. And I'm watching time, we're now at 1:45. I'd like to keep going with raising my issues because I have a feeling you might want to go and have a think about some of these issues over lunch. And that might be the way rather than having another break. So I think if we keep going as best we can for at least another half an hour, and I try and raise the issues with you without necessarily seeking answers from all of you initially, and then perhaps reconvene after lunch where you've maybe had a chance to think about how you might respond to it. It is very difficult responding to individual sentences in a condition quickly because these conditions, especially condition 40 in the guidance notes, interrelate so closely that it's quite difficult to follow. So I'll start with the points that I really wanted to raise, and that was the main purpose of condition 40. And my impression of it is that it sets a methodology in which a noise complaint is investigated, and that the guidance notes then gives the technical methodology on which the actual noise is calculated, if I use the sort of simplistic terms. What I couldn't see really very clearly through that condition is what happens at the end of all of it, and you find there is this problem that the noise is exceeded, whichever methodology or technical approach we're taking. And the only thing I could find was in the applicant's guidance notes, which takes us again right to the bottom of 10.6. and it's in guidance note 4H. H, which would be electronic page 26. Now, I want you to correct me if I've missed something. I can't see anything that requires anybody to do anything about this. It's just an assumption that the noise report will be embedded within that, the solution to the problem, and that the developer will go and sort it. But it in the last sentence it says, in accordance with paragraph E of the noise condition, then the development fails to comply with the conditions. And it seems to reach a point, condition 40 and the guidance notes, that all we do is reach the point where there's a breach. But it's not particularly clear, or at least it wasn't to me, and I've read it a few times, what happens after that. That it's great to establish a methodology for deciding on a breach, but perhaps we need to be clear at how everybody moves forward from that. So that's important. I also, you referred me to the Snedden Law appeal decision, which was, or document for that, 722, as an example of where cumulative noise was being addressed. And I saw that there was perhaps a clear responsibility there in the condition 29, parts 6 and 8, that had some kind of direction as to where the operator of the wind farm went to provide a solution. And then I'm going to ask you a question which I would like some responses to, but I might ask you to see, and it come back to you on the specific questions I have. I'm going to very quickly run through some issues I have with condition 40, because there's a lot of duplication and overlap, which I found particularly confusing to work through, and it's very similar in the guidance notes. But part B of the council's version of condition 40 is now in condition 38. Applicant's part B is the same as council's part C, or appears to be. Applicant's part C is a duplicate of part A, so we've got two versions of the same phrase about appointing consultants. We've got the 2-year monitoring requirement, which we're going to come back to because that's a standalone issue. There is T and E, applicants D, council's E seems to be similar. Applicants part E, I'll just go to that quickly. Condition 40E requires, it says, having regard, very last sentence, having regard to the written request of the planning authority under paragraph C. But paragraph C doesn't have any provision for the planning authority to make a written request. So I'm not quite sure which bit of the condition that's referring to. You might want to have a think about that.
Sorry, could you repeat that? You lost me there. Is that applicant's E you're looking at?
Applicant's version of 40E, and
yep.
The last two lines.
Yep.
Says.
Thank you.
Request, and it's referring to part C, but part C doesn't have that provision. Should be D. It should be part D. Okay. Part G appears to be the same thing, but the wording is different, and I couldn't work out if there was any dispute, in particular, whether it's just preferred wording of G. And applicants part H. Is completely in addition to the council, so it's completely new, and I'm not quite sure what's different from that, from other submissions around that issue. So when you come to the bottom of the conditions with its various subparagraphs, got the two sets of tables. So before we finish for lunch, and I give you a chance to have a look at these issues with the actual wording, I would like to go back to the issue of cumulative noise and maybe just take some views from parties on why the council particularly is resisting the cumulative noise approach that's set out in the applicant's version of condition 40. So maybe just ask the council to explain in a wee bit more detail what's giving them problems with the cumulative noise.
I'll ask Mr. Hewitt to deal with that.
Thank you, ma'am. Yes, is my understanding here is this a question about controlling Clashindarroch 1 via this condition, and I believe this is covered in our noise statement to an extent, but essentially it is a concern that such condition 6 tests in terms of it being related to the development of consideration in terms of relevance, really. But also as an enforcement mechanism. While both sites are to be operated and owned by Vattenfall at this point in time, should there be a separation in the future, would definitely cause issues over enforcement action against a third party, essentially. And really, we don't see a good reason to pursue this approach. When if there was a desire to control them, or if there is a desire to amend the noise controls on Clashindarroch 1, it would be best dealt with through an application to vary the condition on Clashindarroch 1.
Said Mr. Hewitt that it is common planning process. You can impose conditions. Sorry, you're not hearing me, Mr. Trinick. I'm too far from the mic. What I'm asking is, obviously there is a convention that if an applicant controls additional land in a planning condition term, it is possible to impose a condition based on an obligation on that. That is an accepted part of the use of planning conditions.
Sorry, ma'am, you're breaking up. There.
It's my signal's been good so far, but
I think it's the councillor not muting. I think that's the problem. So any noise that's created in their room cuts you out.
Right, okay, because there's 3 or 4 people. Right, okay, so I'll start again. It's planning convention that you can impose a condition when the applicant indicates that they control land next door to your application site. So I'm wondering why you're obviously concerned that the applicant change that level of control through the sale of Clashindarroch 1, perhaps. Is that your issue? Because technically the condition does accord with normal planning practice in terms of imposing controls on adjoining land.
Yes, we can take that away to discuss further over lunch, as other people are. Rather than giving you a response off the hoof, because I think that's a matter that Mr. Hewitt would probably want to discuss.
Yeah, I accept that we're raising some questions. Also, it takes me back to the point I made earlier about the Snedden Law decision and the condition you referred me to there, is that there was quite clearly a separation of control between the 2 wind farms referred to in that decision or in that condition, and that the enforcement would be clearly only ever against the proposed development at Snedden's Law that appeal decision related to. And it takes me back to the point I was making about there being some lack of clarity in condition 40 as to what happens when you reach that point of breach. Yes, we're looking at cumulative noise for 2 wind farms, but who takes the burden of the penalty? And I do accept it's difficult because Clashindarroch 1 has its own noise conditions for you to potentially apply the penalties to those turbines. And that perhaps the penalty will always have to lie with Clashindarroch 2 in those, if we were to follow the Snedden Law example. And that's really my issue, is that if the penalty was clearer in condition 40, perhaps the issue of control would be less of a concern in this idea of the separation of control that might happen through the next 30 years of the operation of the wind farms. And that's why I was trying to get an idea of where the problem lies and actually who takes the burden of the penalty, or which operator or which wind farm. Again, it might be something that has to be dealt with through your lunch break and have a think about it. Mr. Trinick.
Can I just ask for, I don't quite understand what you mean, if the penalty was clear.
Well, what I was trying to say before in condition 40 is I couldn't see a clear direction on anybody to switch off turbines, to adjust the operation of the wind farm. It didn't seem to move to the point of what happens when you reach the point that you agree there's a breach of the noise condition, whether it's including amplitude modulation or not. I'm just looking for that conclusion, this issue of enforceability. So that's where I'd got with that. So I think that's raising that issue. And again, before we break for lunch, I'd really like to explore the issue of the different tables that are then inserted at the bottom of the condition, because these are the tables that would be the starting point for your assessments and any enforcement. Now, the applicants are clearly referring, and I've double checked, so I'm not going to ask you to confirm to me, but their tables are lifted from the supplementary information on noise that was produced towards the end of 2021. The applicants I wasn't quite so sure about, and I wanted to double check, the applicants, the council's table is slightly different, and I was wanting them to confirm where the source of their table was, just for clarity. That would be on digital electronic page 22, table 1, and then table 2, about the daytime and nighttime limits. I'm not hearing anything, so if you're speaking, I think you're still muted.
We just can. Was that a question you wanted to answer now or after lunch? Yeah, you think you're muted now.
It's getting near lunchtime, I know. It was just something I was hoping you would know the answer to quickly, as to when you'd source that table, is to make sure I got it, which document it was drawn from.
Well, I'll ask Ms. Farmer to explain that.
Sorry, ma'am, I understand the question relates to the numbers in the two tables. Is that correct?
Yes, it's just a different set of decibel levels.
Yeah. The council approach bases these numbers on the predicted noise levels that have come from the applicant's noise impact assessment. Whereas the applicant takes a different, I'll let Mr. Mackenzie explain how the applicant reaches there.
Well, I'm still quite keen to push on that, because obviously there was supplementary information about noise levels and cumulative noise levels that we didn't have any view from the council on. So we were, progressed on the assumption that the council did not dispute those particular noise levels. So in referring to the tables that you've inserted, I'm just trying to make sure where you're drawing them from. Mr. Mackenzie does recognise where that noise table comes from, maybe he can help us, but
Dr. Mackenzie, go ahead.
I haven't been able to work it out myself. I spent some time over the last 6 months trying to understand it. I think I may have got there once, but then couldn't. Some of them, yes, they're from the predictions, but not all.
So I think the answer is we don't know and we need to be told.
right, so it might be a matter for something over lunch then, after all. Apologies, I thought you would be able to point me in the right direction of which noise document we were referring to. I think this has ended up an awful lot more complicated than I expected. Well, actually, it's not, because when I started reading the conditions and the discrepancies, I realised this was, if I was to sort out every particular nuance and different wording on each section, I was always going to get in a bit of a fuddle. I think when we come back, we can have a look at what's outstanding from our discussions earlier on about trying to work through the challenges of condition 40 and the points I made to you about that. And we've raised the issue that you're going to have a think about the issue of control and the issue of penalty, and which wind farm operator would carry that burden, because that might help the council deal with the cumulative noise issue. And I'm going to raise with you, but as I want you to have a think about it, I've got a long list of discrepancies and issues to do with the various guidance notes and how similar and different they are at the same time. And I really don't want to waste the hearing's time on it. And it might be that I, as part of our further action, that we look at the guidance notes being submitted as one set that either is suitable for a non-cumulative noise condition and one set that is appropriate to the cumulative noise approach. And that way I can use the ones that are agreed between the parties as suitable in either instance. It might be a difficult challenge to even work that out through the course of today's hearing. It's quite a complex set of cross-reference between clauses and paragraph numbers. I can go through those later this afternoon if you want, but on any review of it where you place them side by side, you will see where the discrepancies are, and I don't really need to tell you that. So we'll break for lunch just now. That's 1:05. I wondered if we could come back at 1:45, just because I really want to keep cracking on with this hearing so that we can start the second hearing around 2:30, 2:45, something like that. Still business to get through this afternoon. So take the lunch hour, but see if you can find some potential middle ground on some of these conditions. Mr. Mackenzie, you wanted to raise something.
I'd just like to end on a positive note for everybody and say to you, Mom, that you can delete 40C because it is a replication of A, and that is completely down to me because I just copied across what the council had said, and yes, we can have that, not realising that it was also there as C. So on a positive note, we can just delete the applicant's C.
The only saving grace is that was probably the only change I was confident in making that wouldn't upset anybody. Thank you for taking that.
Sorry to introduce that.
Okay, so we'll leave it for now. We'll come back at 1:45 so we can keep cracking on and see. I have a feeling we're not going to really resolve everything today, but if we can at least identify where further work is necessary, we might need to use the coming weeks where we're looking at closing submissions to try and tidy up some of these details. So we'll see you back here at 1:45. Thank you. Graham, that's 1:45 now. You're sharing your own screens just now, Graham? That's it. Perfect. Waiting for the council to reappear. Newman, there's the council now. That's fine. Okay. So we left it just before lunch that we were everybody had their, I suppose, their homework to do over the lunchtime period to work out how we approach condition 40 and the issue of penalty and enforcement, and how we address that might be helpful to the council in terms of their concern over the control of both wind farms. The council was going to have a look at conditions that exert control over land that happens to be within the control of the applicant. We're going to look at tables and the source of the noise tables, the noise limits tables, and I'll come back on the issue of review periods, monitoring review, and the guidance notes attached. So possibly maybe go back to the council first and ask them if they've got any clarity on the table, source of the table, and the issue of control over the land in terms of the use of a condition, a cumulative noise condition.
As far as the source of the tables is concerned, unfortunately, what was taken into this table is the information from the original SI as updated in October 2020, and it hasn't been updated for the October 21 readings. What the council does is it rounds the figures to whole numbers. So our figures are out of date, but we had no objection to the applicant's figures, but our approach is to round it to whole numbers. In terms of the basic, perhaps I can, in terms of enforcement, as I understand that the council's approach on normal wind farm is that if the levels specified in the table aren't achieved, then enforcement action is taken. It can be taken to ensure that they are achieved. So there's no penalty as such. The issue of penalty only really arises if there are, who's going to hold the penalty if there are two wind farms within the same area. And certainly as currently drafted, I don't believe it deals with that. In general terms, as to your third question about conditions over land at which the applicant controls, that yes, in general terms, it is possible to have conditions over land controlled by the applicant outside the application site. The issue that arises is how you would enforce that. And I think the concern of the council has been the reasonableness of Clashindarroch 2 taking a penalty when the offending turbine may be in Clashindarroch 1. So that's the issue that the council's been concerned about. So I think that's as far as we've effectively got with the answer to your three queries.
That's fine. Does the applicant have anything to come back on that? If Mr. Trinick's not visible just now.
Yes, we looked at all these issues over lunch. First of all, let's make it clear there's obviously a basic misunderstanding here. The conditions before you only relate to Clashindarroch 2. We could not possibly impose conditions on this permission which regulated Clashindarroch 1. It has its own noise conditions. There must be a misunderstanding here. It's not about control of other land. These conditions regulate Clashindarroch 2, full stop. In terms of the penalties and enforcement powers, there are general powers under the general law, discretionary powers because expediency comes into question, or before the service of enforcement notice, breach of condition notice. In really serious cases, I guess the planning authority could use an interdict if it really saw a need. There are enforcement powers available. And that's the way forward. You could provide for enforcement within a condition, but do real problems arise? Firstly, you cannot displace the general law. You cannot say we will use these powers and the planning authority will not exercise its powers under the 1997 Act. That would take away discretionary powers. It would tie the hands of the local authority. You can't do it. And secondly, the condition would have to be extremely complex to be anything like fair or workable. So, for example, what if there was a breach at 0.5 dB as opposed to 6 dB? Is the same penalty going to apply? Would you shut down turbines just because of a 0.5 dB breach? Would that be reasonable? Would that be proportionate? No, I don't think so. And trying to specify in a planning condition what is expedient, I think, is beyond the reach of a planning condition. That's why the general powers are there. That's why we do not specify penalties in planning condition. So that covers that point. You also asked about Snedden law. Well, Snedden law is a very different case. I was involved in that appeal, and it was separately owned from next door Whiteley, which is quite a big cluster of wind turbines south of Glasgow. And there was no question there of having a cumulative condition. Whiteley and Snedden law are under separate ownership and control. Indeed, the Whiteley were represented at the inquiry to make very sure they did not get penalised or hurt by a permission for Snedden law. So the answer is, in the condition 29.6 or whatever it is, Snedden law takes the hit if anything goes wrong. That's the penalty you pay in those circumstances if you are the second wind farm and you don't have control over the first. Here, Vattenfall owns Clashindarroch 1 and 2, and so the position is very different from Snedden law. But what happens, to answer Mr. Hewitt's point, if Vattenfall were to sell either Clashindarroch 1 or 2, so they came into separate control? The answer to that is that the planning authority can pursue Clashindarroch 2 under the cumulative conditions. Is it fair? Well, you may guess that if Vattenfall did sell one or the other, part of the sale agreement would be a noise sharing agreement between the two developments so that didn't arise as between them. That's not uncommon, it's been done before. And the planning authority need not concern itself with bilateral arrangements between owners of wind farms. It has its enforcement options against Clashindarroch 1. It's obvious that's causing the problem. Say a property to the south of Clashindarroch 1 couldn't possibly be the fault of Clashindarroch 2. But it also has the option, if it says we don't know which is causing the problem, to pursue Clashindarroch 2 under the cumulative condition. And that's a condition which has been volunteered by Clashindarroch 2 by Vattenfall as the owner of both projects. I see absolutely nothing wrong with that. I'm dealing with all the general points at once, and Dr. Mackenzie will come on to deal with the drafting points. The third issue and final issue I need to deal with is 2-year monitoring. We have provided under condition 38 for an initial demonstration of noise rating compliance. Beyond that, it's a complaint-driven system. And I think it's unreasonable, it would certainly be unnecessary to compel biennial or any other periodic testing in the absence of a complaint. Thank you, Madam. Those are my points.
Can I ask a sort of second question of you, Mr. Trinick? My reference to guidance note 4, yes, guidance note 4H, and that last sentence, which confirms that the noise condition, the breach, is on the development. That seems to be quite an important phrase that supports entirely your position. Would that be correct?
Yeah, it's the obvious. Exactly. If the rating level in those circumstances is breached, well, then there will be a failure to comply with conditions, and the planning authority has its options under the general law.
So, if we were defining, and I'm talking on the hoof here, just to see if that's if it gives any help to the council's position, if the development was more precisely defined, as we talked about earlier, about making sure we understood what was Clashindarroch 1 and what was Clashindarroch 2, then that would give that would clarify that the cumulative condition version of condition 40 sat with Clashindarroch 2 at all times, as you've described.
Well, can I just, you haven't quite got my point. It is legally impossible to impose conditions on Clashindarroch 1. Any conditions you have here can only apply to Clashindarroch 2. As they attach to the application for Clashindarroch 2. So I'm not sure the problem even arises.
Right, okay, so we'll maybe go back to the council then with that information and see if they have an updated view, perhaps, on the various versions of condition 40 that are sitting with us, as to whether or not the cumulative version, applicant's version, is becoming more acceptable to them as this debate has evolved. Mr. Finlay, if you're speaking, I'm not hearing you.
I'm just trying to, I'm having mouse control problems. Anyway, I've managed to get it to the appropriate part of the screen, and you can hear me, I hope.
Yes.
I don't think we're in a position to give you an immediate response to that. I think we better understand where Mr. Trinick is and the applicants are coming from. And what I propose we do in response to that is deal with our response in our closing submissions. I still think it's an issue of concern to the council, and I don't wish to commit them off on the hoof to saying yes, we're satisfied. But the discussion has been helpful, and that will have moved on the council's thinking, at least in part.
Mr. Newman has a view on the issue of the 2-yearly monitoring, and I thought it would be useful for you just to offer comments on Mr. Trinick's position on that.
Sorry, we're getting hollow out. Somebody silence himself.
Is that better? Graham, if you're listening, do you know what the cause of that was? Have we rectified it?
Sounds rectified at the moment.
Seems to have gone. So we'll try when Mr. turns his microphone back on again.
I couldn't help notice we've got 2 Julian Newmans on the screen. We have Julian Newman student and Julian Newman guest. I wonder if that's part of the problem.
You're muted on whichever Julian Newman guest is muted. I don't know what the student's doing. still muted, Mr. Newman. Mr. Newman, do you want to try your microphone again and see if it's working? You need to. You're still muted. I'm not hearing you at all. Mr. Newman, can you signal to tell us if you're actually attempting to address this or not? We're not getting any response from you at all. Are you trying to sort it? Yes, he seems to have lost some control over the virtual meeting platform. I think that's his screen frozen now as well. Tell you what, we might need to leave Mr. Newman just now, I'm afraid, and we'll still stick with the 2-year monitoring because I haven't really heard the council's position on that in any detail, whether or not they want to come back on Mr. Trinick's point on 2-year monitoring.
Yeah, we do have.
We've opened to
You're on screen.
yes, the biennial monitoring, certainly that's something that we've been having that included within the condition, from the point of view that from the point of view of obviously machinery does.
Sorry, I'm missing everything that's been said because of papers being moved to the same microphone.
Yeah, no, I appreciate that. You're now the furthest away, Mr. Hewitt, and every time somebody moves in the room, they take control of the mic a bit.
Apologies, I'll try and speak up a bit. I think on biennial monitoring, certainly it's something that we wouldn't have an objection to that being included within any of the conditions. Certainly on the basis that obviously it's machinery does age and impacts do or that may change over time. And certainly, yeah, we wouldn't have an objection to its inclusion.
I think you missed the point. I think you proposed to include it, so we were trying to kind of get a feel for the motivation behind it.
Yeah, but apologies. Yeah, as I said, it's essentially because these are kit that can essentially essentially age and it's to understand what the noise condition noise output is likely to be through the lifespan and to really help keep control of everything and the output and kind of nature of the issues are throughout the operation so that we're not getting into a point where further down the line where I suppose issues have been allowed to compound so really it's it's achieving that.
Right, thank you for that. It explains what your purpose is, really. That's fine.
May I just come back on that, because there's no evidence base for what's been said at all. These are just blades moving in the air. We're not talking about complex bits of equipment interacting with each other. As an aside, the operator has absolutely every incentive keep the equipment running as efficiently as possible to deliver as much power as
Hello?
it will be properly maintained. But the concept that simply because wind turbine blades get older, they start making a noise. So I'd like to know Mr. Hewitt's evidence base for that, because we certainly don't have one.
Mr. Hewitt, is there anything you can add to that in terms of evidence?
I would add that, I would just add that insofar as that is the wording that we include within our model conditions. That is my understanding based on discussions around model conditions. That's why it is included, but I'm afraid I don't have anything else that I could point to.
Okay, thank you. I think we now have Mr. Newman. Yes, he's there. And can you unmute your mic and see if it's working?
Is that okay?
We've had some discussion from the council and the applicant as to why they are for and against the monitoring period of 2 years. But I thought it was useful for you to raise any key points about why you think it's a good idea.
Madam, it seems to me there are several reasons why it is, quote, a good idea, unquote. One is, should it be necessary for the individual resident to have to generate a complaint, possibly repeatedly, if the nuisance is repeated at particular times throughout the year or whatever it may be. So I don't think that residents should have the responsibility thrust upon them of having to compile the complaints, although they should have the right to do so. But secondly, residents are not the only members of the public who have a legitimate interest in controlling noise nuisance caused by a wind farm. And if there is this noise nuisance disturbing recreational users of the forest, which the Forestry Commission, the Forestry and Land Scotland have been very much their credit in encouraging the use of the tranquility of the forest as a valuable public resource and a health resource, really. It seems to me that only monitoring throughout the life of the wind farm could secure that resource for future generations. Also, of course, it will add to the knowledge of experts such as Dr. Mackenzie, the fact that the application of increasing knowledge requires continued investigation. So it would be a public benefit to have this as it's been proposed biennial monitoring, and I'm quite content with the suggestion it be biennial. If the applicant thinks it should be at a longer interval, well, that's perhaps worth consideration. But I do think that given that it's recognised on all sides, I think that it's a very much developing area of understanding, which is understandably difficult because you're trying to relate the subjective, the experience of residents or walkers or whoever it may be. You're trying to relate that subjective experience to and annoyance to certain kinds of objective measures that can be taken. And it's understand. I mean, I compiled just from reading some of the literature in the area, a list of at least 5 possible sources and causes of amplitude modulation, or what is experienced as and called amplitude modulation. Now, all of these need to be investigated and related to the experience of actual human beings on the ground. So I do think that the growing expertise should continue to be applied to an operational wind farm. What's a fair balance of the burden of doing so might well be a matter for debate, but I don't think this should be dismissed out of hand, the idea of biennial or other frequency monitoring period. Thank you.
Okay, thank you very much. Trinic, do you want to come back to that just now, or just address it in closing submissions?
Hello. And now I should turn Dr. Mackenzie on. Carry on.
Not raising any hand. Oh, Mr. Mackenzie.
No, I'm here. I think that really, for a resident to say to the council, I'm still unhappy about noise emissions at my property, the problem of doing has to be contrasted with the cost, the sheer cost to the developer, operator of carrying out this monitoring exercise, which could extend to 2 months worth of monitoring, depending on wind conditions, to determine that the site is still operating as normal. I think that is the principal reason. It's a big workup to do this, and for monitoring to be carried out, say at the more distant properties, which are probably around the order of more than 3 kilometres from Professor Newman's house, to protect Professor Newman's own property is really not appropriate use of resources or cost. And it's not only the cost of the monitoring exercise, that is frankly dwarfed by the cost to the developer having to shut the site down in order to establish the level of any competing noise to determine what is coming from the site and what is coming from elsewhere. So there are huge financial and operational problems to carrying out routine monitoring. That's the answer to the first question. The second question is about recreational use. And quite frankly, these conditions here are to protect residential occupiers of their properties, not to regulate somehow noise levels in the surrounding forestry, where there are no limits to apply. We don't know where there may be people using it for recreational use, but it is frankly irrelevant to the purpose of these conditions, which is to protect residential amenity. The third point which he raised was that it will be good data to have in the public domain if that could be made available every 2 years. Wouldn't it be a fantastic opportunity for science? But I don't think it's for this developer to fund such an enormous exercise every 2 years to provide information for the public domain. The information for the public domain is much more suited to come from numerous different wind farm sites with numerous different operational conditions, topographical conditions, and atmospheric conditions to investigate, particularly AM, which can vary with all those things further. So I think they're the points. As to doing it for a longer period, I don't see any reason for that either. So I think all those things, in addition to what Mr. Trinic said about Mr. Hewitt's point about mechanical systems, I really don't think that based on that 2-year monitoring is going to provide any benefit to anybody.
Could I add to that, ma'am, that Professor Newman referred to a developing area of understanding? No, we've been doing that for 30 years. Normal broadband noise is perfectly well understood. We don't need continuing research to tell us. On AM, that's a different matter. But the biennial monitoring won't just, it's intended to capture the general level of rating noise under condition 40, not the AM. Thank you.
So Newman, do you want to come back briefly?
Very briefly. Yes, no. I take your point that the ordinary. Sorry,
No, you're live.
I am. I take many of your points, but on the other hand, given that it has been suggested, I presume it came from the council, the idea that there should be a biennial monitoring. But given that it has been suggested, I would suggest that there should be that the methods to be used, if there is a biennial study or if it's a longer period of time, that these methods should be regularly updated by some sort of method as expressed in the wording I've suggested, basically derived from Mr. Bowdler's research, which is in my submission.
Thank you. That's really helpful. Thank you. We've given that a good airing, and we've had a good exchange of views on the question of the monitoring period. So in terms of where I was in my agenda, I have covered the biennial monitoring, and I'm left really with item 5 and the variations between the two sets of guidance notes. And I left with you this idea that it wasn't quite a complex exercise to work out where all the differences were. There's a lot of similarities, a lot of differences, a lot of insertion of sentences and some noise, acoustic related terminology, which I'm not in a position to take a view on as to whether it's still relevant in either the cumulative scenario or the council's preferred scenario. I don't really want to waste your time going through it, because it's fairly obvious. If you were to take each guidance note and compare them one against the other, you will find out the extra ones, the ones that have different sentences. It's an easy enough exercise to do. It's just time consuming. I'm going to request that as part of what you take forward from today, that you do look at providing for me a set of guidance notes that are suitable either for the cumulative version of the condition, that's condition 40, or suitable for the council's version of condition 40, which has a standalone set of noise limitations, and perhaps in context with the justification for that table of noise levels. Do the parties think that would be a productive way forward for everybody's time, that they can be doing that really at their leisure and working out where these differences are? Perhaps the council and the applicant can agree what's a set of guidance notes. Yeah,
I'd be very happy with that approach, Ma'am. If Ms. Farmer's happy to liaise directly with me on that, I'm sure we can sort this out fairly easily and quickly.
And if you're just providing with me with an either or option, so that whatever way the condition goes, I've got a good set of guidance notes that everybody's happy, covers the relevant points. Well, that would leave me with one very minor adjustment, and it's the reference right through the guidance notes to something called the noise condition. And it's a bit about just the precision of using that phrase, because you now have 3 noise conditions, and you might need to, when you're drafting it, consider the eventual noise condition number, so that the guidance notes on how they apply are directly related to the correct condition, because we've now got more than one noise condition. So that was a minor observation. I've got the last item on the agenda then is item 7, which is any other relevant matters relating to the noise conditions. Is there anything else anybody else wants to raise before we're finished?
The only item is you raised before lunch the issue of duplication, not merely between guidance notes, but some duplication between the conditions themselves. And in particular, I think you raised, where we are. Well, Dr. Mackenzie dealt with duplication between RC and the council's 40A.
RC and RA.
But that's been dealt. But there are also, you pointed out several other apparent discrepancies. So as part of the exercise after the inquiry closes, do we cover that as well? The conditions as well as the guidance notes?
Oh yes, of course, yes, that would be really helpful because I'm assuming you're looking at a redraft of condition 40 to pick up the points that you were quoting, because obviously we don't have that written down, so that gives you a good opportunity to look at that.
And you'll give us a timescale for our work.
Yes. So, where do we want that to fit in? How does that work in terms of the parties, first set of parties opposing submissions?
I would certainly prefer that that was done before our closing submissions went in, so that we could comment on the final version, because we're going to end up with hopefully two lean mean conditions, which will be devoid of duplication. I was going to say repetition, deviation, and whatever the other one was, but so I mean, I would suggest that we try to do that within a week if possible, or certainly within 2, because we've now got 3 weeks to play with before our submissions have to be in. So a week or say 10 days, then there's something that those that are opposing the proposal can make submissions on.
That's 2 weeks, ma'am. But because of other commitments, 2 weeks to complete that exercise.
Just to add to what Mr. Trinick says, I'm very happy to take the first move and email Ms. Farmer with some suggestions by the middle of next week. Set the ball rolling, and then hopefully we can get a dialogue going, and then we can comply with that 2 weeks from tomorrow, end of the week, whatever the will be. So we can in 2 weeks' time from now.
That's very helpful. I mean, it may be more productive to leave it to the noise experts first, and then only to bring in others later on in that 2-week process.
Yes, I'm not expecting to be copied in or party to any of those discussions. I'm just looking for a tidied up version with as much agreement as possible between the parties. And if there are clear differences, that I have 2 versions of condition 40 I can take forward should I need to into the decision. So have we covered everything then? We've dealt with the issue of submission. I'm just going to check. Yeah, so I think that's everything covered in terms of action points from hearing 2A. Are you content we've covered everything there? I think everybody's happy, nobody's saying any otherwise. So we'll bring this to a close. That's 14:23, and we'll start again at 2:45 with hearing 2B, which is the rest of the conditions. And it could well be that we have some other tidying up to do as a result of those discussions, and hopefully we'll be able to agree a similar timescale to work to with everybody. So thank you very much for your contributions today, those that are leaving us, and I'll see the rest of you at 2:45. Thank you. So Newman, I wondered if you realised you were still with us with the his video on. You might want to switch some of that off while it's the.
Thank you. Thank you. Sorry.
Good afternoon. Is everybody back, ready to start?
Yes, ma'am.
Right. Well, this is hearing session 2B, where we look at the proposed conditions that are not related to noise matters and the areas of any dispute that have arisen from that. It might be useful for the purposes of the record for anybody new to the meeting to introduce themselves that weren't here previously. I think the council has the same participants, but I see somebody new from the applicant side. Ms. Shaw's rejoined us. Perhaps start with the applicants.
Yes, ma'am. My name's Peter Nesbitt. I'm a solicitor with Evershed Sutherland and representing the applicant Vattenfall.
Ms. Shaw.
Susan Shaw, a solicitor with Living Law, and I'm joined today by our expert ecologist, Mr. Dominic Woodfield, who obviously gave evidence yesterday and hopefully has some pretty practical experience to share with us on some of these issues that we're talking about.
Thank you very much. For the record, I'm Elspeth Cook. I'm a reporter appointed by the government and Scottish ministers to consider the inquiry information and to make a recommendation and report to the ministers. So we're starting off with a set of conditions which were just last night or early this morning amended again. It was originally document 10.6, but I don't like working from completely new information, but I need to make sure everybody has something called the track changed version dated 3rd of March 2022. It's essentially the same as 10.6, but with the most recent agreements documented between the council and the applicant. Obviously, the other parties that have concerns about these conditions have not been involved in these discussions. So there still may be a need to look at some conditions at which the council and the applicant have reached a point of agreement on. So we'll start with my agenda, which now includes a lot of conditions that perhaps we may not need to discuss, but we can just cover that over. And just because we're dealing with a piece of new evidence that isn't actually in the core documents, it might be good to just document how the things have changed and confirm that through the course of the hearing for my records, if nothing else. But the first condition that is of concern to the parties is one that the council prefers to have, which is on the section 36 element of the permission, and that relates to the duration of consent, and it sets out that the period would be for 30 years from the date of final commissioning. Council prefers to have it, and the applicant would wish it to be replaced with the planning condition that deals with when decommissioning should be introduced. I think it's quite important that perhaps the applicant explains why they would be reluctant to have this on the section 36 permission, bearing in mind this is first and foremost an application for section 36.
Thank you, ma'am. This is a relatively simple point for us. So we say that the decommissioning conditions, bearing in mind this is consent for essentially plant and machinery, its removal from the site is governed by the restoration conditions, which no doubt we'll come on to speak about from condition 9 onwards. And they more accurately reflect the sequence of events that leads to the removal of turbines from the site. Having a consent simply end on a date doesn't really represent a process of them stopping to operate, a decommissioning scheme being submitted and approved in that time frame, and then the process of actually removing and restoring the site, all of which happens under the terms of the consent and the deemed planning permission. So it's a simple point really that we say that more accurately reflects the process of decommissioning and the end of the consent, rather than it simply cutting off on a set date. So there's nothing between us in terms of the overall term of the consent, but just simply that's a more accurate way of describing the process of it coming to an end.
What is the council's position on that then, in terms of the need to specify something within the section 36 element of the permission?
Well, the inclusion of the particular matter on section 36 consent has come about as it's included within HOP's guidance and the model conditions that they have produced for section 36 consents. And really, it was felt that inclusion with this right at the head of the document would aid in legibility over the next 30 years for anyone picking it up. It becomes quite obvious that it is that the period is the development would be there for 30 years. But I do accept that the points that have just been raised within the decommissioning condition would also cover this to an extent. So I think our positions are actually probably quite close. As Mr. Nimsbit said, we're not contesting the length of permission.
My issue is that the deemed planning permission is a product. If I use that word, that's not maybe a legal term, but it's a product of granting a section 36 consent. A section 36 consent can happen, but the deemed planning permission is a consequence of the section 36 permission. I'm wondering what the justification would be to have a decommissioning period and to ask for the information for the turbines to be removed from the site if the section 36 permission was not subject to a time period. Why would the deemed planning permission then look to decommission the site at a 30-year period if the section 36 consent wasn't in essence in perpetuity?
Is that directed to me, and may I respond?
Yes.
Yeah.
So it will be directed, actually.
So from our perspective, it isn't unusual to have another layer of conditions and requirements that apply to section 36 projects that are contained in a deemed planning permission. The fact that there isn't a specified period in the section 36 consent itself doesn't stop the planning permission regulating the physical aspects of the development and explaining precisely how they're to be removed and in what timeline. There isn't a need for that to be specified on the section 36 consent itself. It doesn't actually need to specify that period of time if it's regulated by the planning permission, and they of course work together and regulate the development together, and both sets of conditions apply.
Does the council have any views on that point?
It's more of it's a legal point, one which we have been discussing just before we started, but our view is that there's no need to have it in the section 36 consent, and that the condition in the deemed planning permission would be lawful and valid as proposed. So it may look odd, but our understanding is that it would be lawful.
Do the other parties have any view on that particular item? I know it's not their main concern from the hearing statements. Ms. Shaw, do you have a contribution on that? No, she's shaking her head. That's fine. Well, I've taken your points on that. That's fine. I'm happy if I had a bit more explanation behind that. Condition 8 was going to be item 2 on my agenda, and I'm looking now at the track change version. Condition 8 was concerning a condition that basically says to do what was set out in the environmental impact assessment. Now, it appears that this has all been agreed between the council and the applicant. It's no longer necessary. So everybody's nodding, that's the case. So I'll record that as being deleted. And that takes us to the conditions we were just talking about, which is conditions 9, which were 9, 10, and 11. The numbering might all change, but we'll stick with those numbers for the purposes of our discussions. So condition 9 is saying now that development will cease to generate electricity. So that's the point Mr. Nesbitt was making, that now that condition 9 displaces the need for section 36 because of that particular turn of phrase. Perhaps that last set of track changes perhaps is making that a bit clearer. Obviously, I haven't had a lot of time to look at them, but it seems to be that you've reached a lot of agreement here by removing the need to specify the decommissioning arrangements in detail, but to agree a strategy. Perhaps Mr. Nesbitt, you can complain that confirm that I'm reading that condition appropriately.
Yes, absolutely, Mum. That's quite right. Our initial concern was having to put together a very detailed decommissioning strategy at the outset of the development, when in reality, these methods improve over time, and one would expect it to be potentially a different set of arrangements in 30 years' time that which we can't predict now, and it's a lot of effort and expenditure that's perhaps wasted at this point in time. So I think the changes address that by having more of a strategy approach at the outset. It's a bit more realistic this far out, which we're comfortable with then the detail of the strategy coming towards the end of the life of the development. And that's agreed between ourselves and the planning authority.
Yes, that's fine. So I've picked that up correctly, and just the change in the terminology. I see there's still some reference to aftercare, and is that something else that's been you've all reached an agreement as to what aftercare consists of?
So I can probably help with this one as well. This is a difference between us in relation to the way in which the restoration and financial guarantee provisions operate. We haven't yet had it explained to us by the planning authority precisely what they consider is meant by aftercare in this context. In actual fact, the main operations that are covered by the decommissioning arrangements and the financial liabilities are around the physical works of restoring the site. In actual fact, once that's done, there isn't a great deal of aftercare involved as far as we are concerned. But I'm very happy to hear different views on that.
Perhaps the council can confirm if they still have issues with the way aftercare has been treated within this condition and presumably within condition 11.
Thank you, Ma'am. In respect of this condition, really, when it comes to aftercare, I suppose the main concern of the council is we don't want to close the door on aftercare at this particular stage. We're saying that a strategy will be submitted, which will allow us to get an indication of what restoration is going to be carried out, and based on that, we can understand and make a judgment at that point as to whether aftercare is required. And I think the point is we don't want to cut off that option at this point, because if aftercare is required, we would want to make sure that it can be appropriately factored into any financial guarantee for later conditions, really, so it doesn't become a liability for Aberdeenshire if the worst were to happen. It's not necessarily a statement that we have grand expectations of it at this stage, but we just want to make sure that it is something that can be considered in detail once we have a little more to go on with the restoration strategy.
I don't want to enter into particular confidential matters, but obviously I see it in condition 11 that you're making provision for the financial device, financial guarantee, whatever option you choose, that is going to have an option for it to benefit Forestry and Land Scotland, who I presume are staying the landowners underneath this development. Does that make a difference to the issue of aftercare if that financial guarantee could then default to Forestry and Land Scotland? without necessarily going into any confidential matters.
Mark, just in relation to the aftercare provision, just understanding how these matters typically work in relation to wind farm restoration, how it's worked on previous consents. Aftercare just usually isn't a feature of these conditions in our view, because the arrangements are so modest after the restoration's taken place. The restoration itself, of course, is quite a considerable operation, and that's why most applicants consent to a financial guarantee provision. And occasionally, if there's another landowner involved, that may extend to covering them in similar situations, which is why you have mention of it in the condition. But in terms of restoration, we would say that isn't really what financial guarantee is there to cover. Those activities are so modest in comparison to the restoration provision that it seems unreasonable to have the financial guarantee rolling on beyond the significant restoration works that would occur.
So do you have any views on the aftercare and the financial provisions?
Yes, I'm aware that Mr. Woodfield, I think, would like to speak on some of the issues on aftercare. Just before that, I wanted to note, going back to condition 9, if I could, the reference at point L to the species protection plan. We see that includes a plan based on surveys for protected species, and we just wonder if it could be inserted there, including wildcat and birds, or if that's considered to be covered elsewhere as a point of clarity. And I'll hand over there to Mr. Woodfield on the aftercare issue.
You ready, Mum?
Yes, carry on.
Hi there. Yeah, I have direct experience of overseeing wind farm construction, and I query whether the 3-year aftercare provision is sufficient. Obviously, we're hampered because we don't understand exactly what might be agreed by way of aftercare and restoration, but it is entirely conceivable that it would be something like a restoration to an upland heath habitat in that location. The 3-year aftercare, and in fact some of the language used by the applicant around this seems to suggest that they may be thinking something very de minimis along the lines of removing the turbines, excavating the bases down to 1 metre and then just backfilling and then walking away. Well, I think that's not likely to be acceptable to the council or anyone else. If what is ultimately agreed is something a bit more involved, upland heath and restoration, for example, then experience tells me that you're going to need an aftercare provision to ensure that that habitat establishes in the way that's satisfactory to all parties, and that may well take it beyond a 3-year period of monitoring and potentially interventions to try and prevent the habitat heading off in the wrong direction. And in that context, 3 years, I think, is potentially questionable as to whether that's sufficient. I am relieved that the applicant has moved away from the previous comments where it was saying that no aftercare arrangement is relevant, but I'm just querying whether even the movement towards agreement on 3-year aftercare provision is sufficient.
Mr. Nesbitt, do you want to come back on the 3-year period?
So in terms of the restoration provision, there's been nothing presented to us so far that would suggest that the arrangements are that complex. And, in terms of the restoration provisions, they cover what they cover. They will, of course, be set out. It will be a public process of approval to these matters. They don't just disappear out of the public regime because they're submitted under a condition. Whatever's submitted is in the public domain, and third parties would be able to comment on it at that time. We do think that having aftercare beyond restoration it is not necessary in the circumstances.
Mr. Nesbitt, would you like to come back on the public involvement in the conditions, clearing conditions on the deemed planning permission? Or sorry, Mr. Finlay, but the council had a view on that.
Thank you, ma'am. It would largely, in my view, depend on the mechanism that's engaged to assess the conditions, and generally on a lot of projects, the Aberdeenshire Council officers would use delegated powers to agree conditions, and we would generally only go for an application for matters specified in conditions for planning permission in principle, as opposed to agreeing the document that has been submitted. And generally that is done really because these matters can be quite technical, and they're something that, I suppose, for time reasons as well, using delegated powers is simply a faster process. So I wouldn't like to say that we can guarantee that necessarily there would be an application process through which this can be agreed that the public would necessarily be able to comment on.
If I could also make a further point.
Yes, carry on.
I think we need to remember as well that this is a commercial forestry, which will be restored to commercial forestry after the operational period of the development, which is certainly in our mind. And these are the matters that have been assessed in the environmental impact assessment report, around how this is decommissioned in the circumstances. And no party to date raised any issue about aftercare outside of this condition session.
Ma'am, could I just raise a point in response to that?
Yes, very quickly.
Yes.
Yeah.
That's the applicant's intention, and that may well be how it looks at the moment, but we're talking 30 years hence. If it's restored to forestry, it could well be that at that point in time, that's seen as a net loss of biodiversity and is seen to be unacceptable for all sorts of reasons. So I don't think we can preempt what the position might be in 30 years' time. And if the position in 30 years' time agreed, whether involving public consultation or otherwise, is for restoration to a habitat that requires aftercare, then it seems not very sensible to restrict the provision of the delivery of that now.
Okay, thank you very much. I think I understand the different positions on aftercare and what we're trying to, I suppose, second guess where we might be in 30 years' time and whether the original strategy is delivered as planned. I'll have a look at these conditions in that light, but I think I've got enough information to move on from that particular issue. I do have a couple of questions on the financial guarantee element of condition 11, and I'll just come to it. I know it's agreed. My first comment was, and it was going to be, but it's obviously covered, is that I didn't feel you would be able to create a value for financial guarantee unless you had a restoration plan of some sort. That it would be very difficult to value it unless you had first created a plan that was capable, that had enough detail that you could place a value against the long-term cost to someone else having to carry it out. But it struck me, I was a little bit concerned about part C of condition 11, because what it says is that the financial provision must be reviewable at least every 5 years to ensure that the specified amount of the guarantee always covers the value of the site restoration. It's semantics, but I think there's a difference between shall be reviewed and shall be reviewable. Designing something that could be reviewed is different from actually carrying out the review. And so I would probably look for that language to be a bit clearer, that it actually is reviewed every 5 years, so that in close proximity as we get to the end of the 30 years, we do still have sensible financial provision that is up to date as close as it can be. But that's an observation, and maybe one you might want to take on board. That takes us to the next condition, which originally in item 4 it was going to be condition 15, which has been agreed in the interim which is about the construction environmental management plan. That is all working quite well. I have a quick question again about wording. I see here in the agreed provision, there's mention of an ecological clerk of works, and in other places it's called an environmental clerk of works. Having a quick check, SEPA seem to prefer ecological clerk of works, but having a quick kind of look at it, it seems that they are essentially the same post, but it might be prudent that it's the same terminology all the way through, so there's no doubt as to who's been appointed, and that the other references in other conditions to that particular role is universal. So it's a wording.
Ma'am,
Have any?
yes.
Yes, I was wondering if you had an input to this.
I think we had a couple of inputs in relation to provisions about who is consulted and whether Nature Scott should be consulted, and the interlinkage between condition 14 and 15. So if I might hand over again to Mr. Woodfield, I think it might be useful for him to explain some of those points directly.
Thank you. Yes, ma'am. Again, drawing on practical experience of how these things work in real life on the ground. Yes, I think there needs to be some clear linkage between the construction method statement and the construction environmental management plan. The presence of an ecological clerk of works will help in that respect because they will be expected to be conversant with both documents. But I think it would be helpful, perhaps as a clause within condition 14, to say that it will include cross-reference to the construction environmental management plan, because otherwise what tends to happen is the contractors look at one, the one that interests them and is more relevant to what they feel is their day-to-day job, and they don't look at the other one. And like I say, an ecological clerk of works will help in that respect, provided they're given adequate powers. As Ms. Shaw says, I think it is an omission in condition 15 not to include Nature Scott as part of the consultation. SEPA are there, but I think Nature Scott really ought to be as well as part of the bodies that the local authority consults with before approving the construction environmental management plan. And then there are some sort of practical wording elements that I think will help to tighten it up, which I'm happy to suggest. For example, under A, sub-provision A of condition 15, risk assessment of potentially damaging construction activities. Well, to be honest, all construction activities are potentially damaging. So I think that risk assessment should be for each discrete construction activity, for clarity and for firming up. Under B, identification of biodiversity protection zones, I think wording would be usefully added here in terms of how the protection of these will be delivered, enforced and monitored. And I noted you'd picked up this point about fencing in relation to the archaeological fencing condition. I think there needs to be some cross-fertilisation between the possibility of fencing biodiversity protection zones as well, because there may be instances when that's appropriate. Practical measures to avoid or reduce individual identified impacts, I think that again could be tightened up a little bit. The role and responsibilities of the ecological clerk of works, the wording there kind of implies that the ecological clerk of works is optional. I think we are now in a situation where that could be tightened up to refer to the ecological clerk of works rather than an ecological clerk of works. Use and design and use of protective fences, I think we need some information on the design of those protective fences as well. There is a huge difference between robust British standard protective fencing for root protection zones for retained trees and a couple of pins with a bit of holographic tape stretched between them in terms of how they actually function in reality. And then again, I'm noticing in the conditions this imprecision between mitigation and compensation is slightly drifting back in. So under I, the details of resultant mitigation or compensation, I think that precision is quite important. And then just in terms of the reference to SEPA again, I think that ought to be to SEPA and Nature Scott if this condition is to be as robust as it ought to be. Thank you very much, Mark.
Can I just come back on C? You said tighten up, but that's not very precise. Tighten up. So what was lacking?
So practical measures, both physical measures and sensitive working practices, as it's written, to avoid or reduce impacts. Well, I think that needs to be precise. So to avoid or reduce individual identified impacts, there needs to be a process gone through of identifying the potential impacts in the same way as you would in an EIA, and then setting out the practical measures against each, rather than kind of dealing with it in a nebulous way. The problem is that in reality, contractors on the site, they need to be led by the nose to actually adopt any of these things.
Mr. Nesbitt, do you have a view on the additional terminology that might appear? I mean, it's not very precise yet, but the ideas that have come through Mr. Woodfield's comments.
All I would say is I think Mr. Woodfield is approaching this as though it is the construction environmental management plan rather than a condition requiring its submission and approval. You know, these are the sorts of things that you would look to fine tune in an actual plan that's been submitted to the planning authority. And I'm sure that's why the planning authority haven't set it out in any more detail than is already there. I mean, arguably, we would say this is already too much detail when you've got to go through a process with the authority guided by an environmental impact assessment report that's already there and present. You know, during the planning process and prior to construction even commencing. My only comment is I think you could work forever on a condition and it would eventually become a SEMP in product, but that is what this process is for. To require its submission and then approval by the authority. No issue at all with Nature Scott being consulted. We tend to add, or the council's added those consultation requirements into the condition. Of course, they may consult with whomever they wish in relation to any condition submission, and no doubt would consult all of the appropriate bodies.
And does the council have a view on the potential change to wording within the condition? You know, it's very general at the moment because we have nothing besides.
Thank you, ma'am. I think on particular points raised, I think Mr. Woodfield has raised a lot of the content that we would expect to see within the eventual document. I think that there are perhaps points of it that clarity may be beneficial within the condition, but again, the devil would be in the detail of the precise wording of that. But I do think that the condition as it stands is broad enough that that detail could still be submitted as part of the SIM.
If I just to come back on that point about too much detail very, very quickly. Generally, this level of precision is, in my experience, is helpful to whoever actually produces the construction environmental management plan, and it's also helpful to the council because they then effectively have a checklist of the requirements of the SEM and the detail to tick it off against. So that is the spirit in which these suggestions are made.
Okay, thank you. I understand what you're trying to do there, and I think the points are quite clearly made. Thank you. Now, did I have an issue with that for you? All right, so we're on to item 5.
I'm sorry, just before you move on, apologies. Just one final point is that there is, of course, an outline HEMP in the environmental impact assessment report that's there for guidance for anybody producing a CHEMP to comply with this condition in due course. That may just be a reference you wish to turn up when you're looking at this matter. Thank you.
Yeah, thanks very much. This is well remembered. So item 5, we're looking at traffic management abnormal load conditions. Now they've all been agreed in the interim. I have an observation. I know you're not in disagreement about it, but it's the you've placed in verbatim at the end of Council's condition 18 two conditions which I found have been taken from the Transport Scotland consultation reply response. I appreciate that they are important. The Transportation Scotland conditions are important that they're included. It's just the way that they've termed it is quite different from perhaps the way that it should function in terms of its grammar and structure in the context of this document. And it's I forgot. Or has it been taken out? Oh no, it's abnormal loads, item 1. The proposed route for any abnormal loads on the trunk road network must be approved by the Trunk Roads Authority prior to the movement of any abnormal load. Well, I have an issue with this condition instructing that another organisation must approve something. It's strictly speaking, if we were to look at how conditions are framed, you wouldn't normally do that. You would normally look, as we've done with the environmental management plan, the idea if you would involve that body in the final approval of that. And I think there's something similar in the second part to do with must be undertaken by a QA traffic management consultant to be approved by Transport Scotland before delivery commences. Again, it's grammar rather than the purpose, but it's maybe something worth looking at just to make sure that we take the essence of the Transport Scotland condition, but sometimes taking it verbatim doesn't always fit neatly into a planning document. Now, that takes us to item 6, which was going to be a detailed debate about micrositing, which you seem to have got to the bottom of, and apologies, I've in the interim period, and it was just agreed this morning or last night. And it appears to be that you have created certain turbines where there's a greater sensitivity, and you're content that they should have some more scrutiny before the micrositing takes place, and others where it's less important. And you've addressed some information to do with water courses and separation from that. Is that my correct understanding, Mr. Nesbitt?
Yes, entirely correct. You've understood the condition perfectly. It resulted from the evidence and the exchanges we had in the landscape and visual impact assessment section of the inquiry, and then obviously we agreed this condition around the sensitivities with those particular turbines.
Michelle, did you have anything on micrositing? I don't know that it overlapped with yours, right? Thank you. And that takes us to item 7, and that I've put down here as conditions 24 and 26, but it's really a suite of conditions, 24, 25 and 26. And the reason for raising it, obviously at 25, we've got the environmental clerk of works there, which is slightly different from the ecological clerk of works. I'm just including that now just to highlight that's one where the terminology is different. So I know that perhaps Ms. Shaw will have some comments on this, and we've all. Did you have had a look at the track change version from this morning? I'm going to raise some questions first because it might just be helpful if we look at all the issues as a oneer. I have some concerns that there is not a direct relation to the mitigation measures as listed in the environmental impact assessment report, whatever they might be, and including the outline habitat management plan and the outline species protection plans that are there. And I'm wondering if it would give it greater accuracy if the mitigation that these documents were intended to deliver was expressly linked to what's listed in the environmental impact assessment. Mr. Nesbitt.
Thank you, ma'am. Yes, is the simple answer. We accepted the council's condition on this point, but if we went back to our original proposed condition, it did exactly that. It cross-referenced to those measures in the environmental impact assessment report. We were initially quite happy that this did the job. But actually, on reflection, looking at it, several things have fallen out of that. Now, we captured one of those yesterday evening, which arose through the evidence. It needed to pick up the point about wildcat woodland blocks and the mitigation around that. But I think it would actually, there's other elements to it, which I think you've picked up on your agenda as well in relation to the financial contributions to a wildcat monitoring officer. Actually, that is picked up within the outline HMP that's in the EIA report. And I think it would be better either that we change this condition so that in the second paragraph, it makes reference to including the mitigation measures described within the outline HMP in Appendix 9.5 of the EIA report. That's CD 1.5.2. So it has a direct reference. And then, by all means, it can list the matters that the council has made reference to in its draft condition. And I think that would hopefully cover that concern, ma'am.
Yes, I think I'm obviously going to take some comments from Ms. Shaw, but obviously the deliverability of mitigation is quite important here. We heard that through the inquiry session on Wednesday. Maybe we could hear Ms. Shaw's points on this, because I'm sure you've got something to add here before we take answers from the participants.
Mr. Trinick, I'm not dealing with the conditional session, so I'm going to, I'm being allowed to start on my very long drive, and Nesbitt will finish off. So thank you very much for everything, and goodbye to you all, and thank you very much.
Okay, thank you. Thanks for your effort.
I wonder if it might just be helpful to sort of set the context a little bit in terms of the overall nature of our concerns relating to conditions on the ecology matters. Obviously, some of those came out in evidence yesterday. I think we have an overall concern that there isn't sufficient detail at the moment in terms of the outline habitat management plan and the species protection plan. There are separate concerns around the deliverability of some of those issues because of the possible discontinuation of existing structures, such as that around the TNVR project. And then the issue about the funding for a wildcat officer, and whether I noted Mr. Nesbitt had made a comment in relation to that, but we wonder whether there is an intention for a Section 75 agreement to be considered in relation to some of these issues. I'm
obviously going to just kind of caution you a little bit, because obviously these conditions are not intended to address your concerns.
No.
Do you know what I mean? They're not. We're not looking at a set of conditions that deal with an outcome that hasn't yet been reached. Mm-hmm. So the conditions are assuming that the proposal in front of us progresses. That's one of the problems of this process, is you have to look at the conditions as if the development in front of us is the one that moves forward. So while you may be concerned about the content of the outline habitat management plan, for the purposes of this condition, you have to assume that that remains unchanged, because it can't be changed. We can't go back and rewrite something that is in itself an outline document that is complete and finished. So just bear that in mind, because obviously what we're doing is we are working slightly in a bubble in terms of the status of the proposal, but we have to assume that the one in front of us is the one that moves forward.
That's completely understood. I think just have to re-emphasise the points on behalf of my client, but that position is obviously noted, and I know also obviously we're dealing with quite standardly used conditions in this context, which we might not always see as being robust as they might be from a practical perspective. But I'll hand over there to Mr. Woodfield if he wants to make any more comments on the specific issues.
Thank you.
Thank you. Yes, thank you, ma'am. I'm not sure whether Mr. Nesbitt's suggestion is now going to be taken forward and there's going to be some reversion to the cross-reference to the SPP in the outline habitat management plan, because if there is, that may deal with some of my concerns over the wording of this condition, which I think is a little bit imprecise. Mr. Nesbitt wants to come in just briefly on that.
I just thought I could help you with that. That is certainly my proposal. We haven't heard from the council, but yes, I think it would be very sensible to make that link again as we'd originally proposed and has somehow fallen out of the drafting.
So would you look at I'm taking the evidence here, and then we can maybe look at whether or not there are actions for the parties. But what we're trying to do is discuss potential change.
Okay, I'll keep it to the headline point on this condition then, which is that, and forgive me, I'm going to sort of start dabbling in areas that I'm not sure on, but I'm sure we'll soon be corrected if I'm straying. Is it possible for a condition to enforce the delivery of compensatory habitat planting on third-party land? That seems to me to go against the grain of my understanding of what conditions are capable of doing. And obviously, to the extent that this condition makes reference to compensation measures such as improving habitat connectivity for wildcat between Clashindarroch Forest and other woodland blocks, that's going to require third-party land, which is, in my experience, going to require a separate legal agreement.
If I might just add one point here as well, as I think that the general overarching point is we're not clear about what is meant there by large woodland blocks. We're not cited on any detail in relation to the plans.
Well, precisely, we have no detail, but in any event, it seems very likely that it is going to include third-party land. Mr. Bradshaw yesterday said that there had been discussions with third-party landowners. So my question really, the overarching question is a condition the appropriate delivery mechanism in that context?
Well, I'm not really going to go down the line of that, because what I want you to do is say that that's something you're worried about in the condition. And perhaps we take that forward as your evidence, is that
open question then.
Sure, deliverability is clear, and I would take that rather than be answering your question directly, because this is what we're hearing evidence.
Yeah.
Okay. Your next point.
That was really it. Other than I'm going to continue to make this point because again we seem to in the wording we seem to be confounding mitigation and compensation again, and I think to the extent that all of the evidence and all of the balance that you have to strike, Ma'am, in your report to ministers is about matters such as whether the mitigation hierarchy has been properly followed. I do want to ensure that what is compensation is called compensation and what is mitigation is called mitigation.
Is that your main point then, the stability of the full range of measures?
I think, sorry, there was just one other point that as written, again, says the development should be carried out in accordance with the agreed species protection and habitat management plan unless otherwise agreed in writing with the planning authority. And again, I think for the avoidance of doubt, it might be worth adding in consultation with Nature Scott on the end of that.
I'm probably going to come to the council here because obviously it's been there. They have authored this condition and see how they feel or if they have any response to the comments.
Thank you, ma'am. I'll try and keep it quite brief. Certainly would not have any objection to tying in references to mitigation outlined within the EIA. That does seem a sensible approach to provide that linkage within this condition. And as for a few of the other points, really a lot of the agreed wording within that, there were additions from the applicant's part to try and add a bit more precision to the condition. Certainly, I think there is some food for thought with some points that the appeal has just raised.
And I would probably come back to it, Mr. Ned, but on the issue of deliverability and matters that maybe aren't there in the outline, my habit management plan, and that is on timescales and delivery of certainly the off-site measures and some of the financial measures, because my take on this is that there's not a suspensive element to the internal content of the habitat management plan. There's a suspensive element to submitting it, but we can't know at the moment whether or not that would suspend development until certain items were in place, such as the off-site works and financial arrangements for funding a project officer or the neutering program. So if you have any comments on that?
Yes, ma'am. I don't think it's at all unheard of to have conditions that relate to land outside the application area. This is a condition that would bite pre-commencement. And so the arrangements set out in this document would have to be approved by the council. Now, those arrangements would, at that point in time, be informed by whatever the position is at that stage with regard to discussions with landowners. There will be, by that stage, a much more formulated strategy around the land available, which of course will at that point benefit from an agreements and confirmations that can be relied upon. So our view is that this is a matter that can be dealt with in this scheme. The scheme itself can set out the arrangements for its phasing implementation throughout the course of the development and before it, and then is a matter for approval council. Now, in fact, the scheme itself can also deal with the financial arrangements for funding it. That's entirely possible within a scheme of this sort, expressed as a pre-commencement condition. So all of these matters can and would be addressed in the proposed scheme.
Right, thank you. Does the council want to come back on that point?
No, I don't think we would have very much more to add on that.
Mr. Woodfield?
Just a very brief point, Mum. What happens if no landowner can be found to buy into this scheme, or no land is made available that actually delivers what the intention is, which is to connect up these larger blocks within the wider Strathbogie area? I've been in this situation before where a developer has sought consent contingent on the delivery of significant off-site compensation. And when challenged on the deliverability of that off-site compensation, ultimately was found that it was not possible to deliver. So that is an illustration of the genuine concern here.
Mr. Nesbitt, I think you wanted to come back on that.
Yes, please, ma'am. I think we're in the territory which will be familiar to you around suspensive conditions. We say, having spoken to a number of landowners, there's a very real prospect that this can be delivered. Of course, it is up to the council to decide whether that scheme is acceptable, no doubt taking input from any party that wishes to participate in that approval process and give comment, not including the statutory consultees. So, I hear what Mr. Woodfield is saying, but there is a mechanism there to control that eventuality. If it can't be delivered, then I dare say the council won't be willing to approve the scheme and the development can't start. So there's a mechanism that bites to cover that situation.
Well, I'll just say that I guess it ultimately comes down to a matter of how much weight you feel able to put on this in the absence of any real detail here.
Oh yeah, and it's not. I say we're progressing from the point of view that we have, that it's based on the information that we have, not on information that we don't have. I've got enough information. I think that's covered my questions. I'll just check. I raised in the inquiry session with Mr. Bradshaw the issue of combining the species protection plan and the habitat management plan. He was particularly worried that they were combined into one large document. I apologize if I gave the impression that I thought there was a dispute, but it was more that the condition would have come under discussion today. So I knew that the nature of the condition would have been debated today. It's not that I have a hard or fast view on it, but I was wondering if the option of separated or combined would be prudent, bearing in mind that the timescale for securing and setting out species protection plans might be quite different from when you can put forward your habitat management plan, and that if you're obliged to kind of wait till you can present everything, that might be more problematic. But it was just to give you the option that you could choose at a later date to separate them out, if that was more viable in the circumstances that you face. Mr. Nesbitt's nodding, so I'll take that as
That was in fact our original proposed set of conditions, where there were two separate documents. So we'd be very content with that arrangement.
Does the council have a view on that?
Thank you, Mark. I don't have a particular issue with them being separated out, provided they are still suspended conditions. I don't think it's going to make a great deal of difference in that respect, whether they're one or two or more documents.
It was more a case of whether or not it obliged the applicant to go down only one route, and it may have proven difficult at the time. Mr. Woodfield, you wanted to raise something there?
I don't think I did. I have a point on condition 25.
That's okay. It takes us to condition 25. And no, it was condition. It's condition 26 that tucks into the end of this set of conditions. I was going to just raise a point on that, but you were wanting to raise something on condition 25, Mr. Woodfield, before I move on.
If I may briefly, and apologies, I'm going to present this as a question to Mr. Nesbitt, really. The reference in condition 25C to the stock powers awarded to the Ecological Clerk of Works. Could he explain to me how they are intended to work in reality? Ecological Clerks of Works tend to be, I mean, in this situation, they'll be employed by the developer, and they tend to be stationed on site with the contractor, the construction contractor. They need every little bit of help and encouragement they can get to stick their head above the parapet when they see things that aren't going right. So I'm just wondering if you might be able to give myself and you, Mum, some reassurance that stop the job powers are something slightly more than just a throwaway comment on a piece of paper.
All I could say, I'm certainly not an expert in executing commercial projects on site, and I couldn't claim to be, but the condition says what it says. I can't really take it any further than that, Mum. It's, as you know, it's an enforceable condition. So, and I would expect any ECAL to assert themselves properly in that situation and have regard to their professional duties.
That takes me to.
Sorry, Mark, I might just add one minor point. There's the use of the word practical opportunity in there as well. I appreciate again that this is standard wording, but just it seems a little bit weaker than it might be.
Okay. Mr. Nesbitt, do you have a view on that?
I think it just means if they're not under a duty to act in a way that, you know, if they're on top of a hill and they're not near a mobile phone or something like that, they've just got to do it when practical. I mean, that would just seem to be common sense, but I have no strong view on it.
Do council have any view on that point? Just shake your head if it's no. No, that's fine, Mr. Hugh. I can see you in the distance. Yes, condition 26. Just a couple of things, and I think it's about tidying up. The first phrase is no development shall commence until a survey method statement has been submitted to. And obviously this is about surveying for protected species. I wondered if the survey method could be a bit more precise so that it's clear. The survey method at 26 is the survey results in the second half of the condition. And we find the separate species protection plan and the bird protection plan have to be submitted here prior to the commencement of development. So there's a second requirement to submit the species protection plan. I wondered if that was really necessary. I think it's just because these are all being drafted at different times, but I think it's just a tidying up exercise. If I could just draw that to your attention, and we could find the best place to put in the approval of species protection.
Can I make a suggestion, Mum?
Woodfield?
but hopefully a helpful suggestion. It would seem to me logical to put the survey methodologies and the timetables in with the species protection plans and the habitat management plans, and therefore they're all under one umbrella and can all be submitted and approved under one mechanism.
Yeah, well, I'm sure Mr. Nesbitt looked at that, whether or not that's beneficial or not, but like everything, you're trying to create clear stages. Mr. Nesbitt, did you want to come back on that? I wasn't sure if you were chatting to me or not there, sorry.
Sorry, I was receiving some instructions there, which is why I was a bit distracted. Could you just give me one moment, Mum? Apologies.
Yeah, no, that's fine. Carry on.
Apologies, Mum. I was just taking some quick instructions there. Apologies for getting distracted. So I think that the view I was just being given here was that there is some benefit in keeping these things separate in order that you can, as you mentioned earlier on, discharge them at the right time in the process. I can't claim to have a particularly strong view on this, as long as it all gets done under the conditions. I'm sure we're covered, but I think some separation is perhaps helpful from a discharge perspective.
Yeah. I think it's quite possible as well, because I suspect Mr. Woodfield will keep me right, but obviously there are optimum times for protected species surveys that might not align directly with, say, the habitat management plan work that you're doing. So I think that's my main points on the group of ecology and ornithology conditions. And that takes us to item 8. Was Mr. Woodfield?
Well, sorry, just very quickly on condition 26. Again, the same point has been made several times already. I think it would be logical and helpful to have, in consultation with Nature Scott, added in where relevant into that condition.
Right, so item 8, over in the home straight, is condition 32 on protective fencing. Now that seems to have been agreed. There was a concern that there was no need to do a separate one for archaeological areas, because I think this was its main purpose, was to deal with archaeological protection. Is that correct, Mr. Nesbitt?
That's correct, Mum.
Yeah, and the council are happy that you found an agreed position on that, so it's fine. And then there were a set of other conditions which seem to have all been sorted out in the interim. It seems that condition 27, 29, 30 and 34 have all been agreed as the draft conditions have evolved. And I saw earlier on in 10, the first version 10.6 is that you've added in condition 37, which was picking up Scott Way's issue about right-of-way access through the construction site. And that all appears to be sorted. I'll just check. Nope, I have a blank page, so I am now at the end of my agenda. Is there any other conditions matter that I've missed? Mr. Woodfield.
Yes, ma'am, thank you. Just a couple of very quick points on conditions 22 and 23, which relate to borrow pits. Very small trite point of accuracy just under 22. I suspect wording should be working in the third line. Just a point of syntax there, but more specifically, where it says the details shall comprise, and then there's a list of A to F. Under D, I think, again, tightening up the method and timing rather than just the timing and phasing of the extraction for each borrow pit. I think there needs to be some control over methodology for the borrow pits. I think that makes sense given the sensitivity of the environment there. Yeah, the reason there is primarily for, and that's perhaps why the omission has been made, the reason is for recreational and visual amenity. Obviously, there is a biodiversity consideration here as well. Reasons aren't necessarily the most important part of the conditions, but for precision. And then in the condition 23, it just occurred to me that there must surely be somewhere a code of practice for blasting in these sorts of situations that could be cited and adhered to within this condition. There are provisions put there, but yes, I imagine, I don't know, but I imagine that these things tend to be governed by some good practice standards. And I think it would probably be helpful for those to be referred to within that condition.
I might ask council about that if they've got experience of referring to such a document. No, Mr. Hewitt's shaking his head, doesn't not aware of it. Mr. Nesbitt, that before?
Not sure I can help you with this one, Mum. It's not something I'm familiar with. Relevant witnesses have fled the building, so I don't think I can help you with that one. But I'm sure we could into it.
Okay. I have a recollection from my previous job that there is such a code of practice, but it's more relating to mineral extraction rather than borrow pits per se. But there could well be something that's relevant just to the act of blasting. Well, I think we've come to the end of the hearing. Ms. Shaw is going to raise something.
Just a very minor point in relation to the outline habitats management plan. Would the council normally publish that on iDocs when they receive the draft from the developer in due course? Just to establish what opportunity there might be for public comments to be made to the planning authority.
It was more or less along the lines of what I was asking earlier, Mr. Hewitt, as whether or not the council would actively open up plans submitted under condition for public view, for public opinion, as opposed to being able to see it. Are you able to confirm what Aberdeenshire's council's view, procedures are?
Yes, ma'am. At present, whenever we receive habitat management plans or documents of that nature, they are generally dealt with under delegated powers, so there generally isn't an opportunity for public comment. We don't normally accept public comment, and it's because we don't deal with them under an application process as such, which I am aware other authorities sometimes do. Notwithstanding the interest here, I wouldn't like to at this stage commit ourselves to effectively changing the process that we normally work by.
And as a question, would you normally, I know everybody uses online file storage now, if something like this was coming in and it was about, it was being processed normally but without public involvement, would the actual document still be made public on your internet file for this?
The document is usually uploaded onto the file. They are usually made public. I would need to double check the timing of that, whether it's once we have agreed it or whenever it is actually submitted. But they do end up on the file unless there's a specific reason not to.
Thank you. Does that help you?
Very helpful clarification. Thank you. I mean, it's not necessarily even an opportunity to comment, even if it's simply published on iDocs, so that the document is, available for public scrutiny.
Yeah. Mr. Woodfield, were you going to raise something on that?
Yeah, it is a point of concern. I mean, I don't think Aberdeenshire are unique in this kind of default to delegated powers in relation to condition matters. I don't want to stray into legal submissions because I'm not a lawyer, but there may not be no statutory compunction to consult on conditions, but there is a common law duty for the planning authority to involve members of the public when there are situations of significant public interest which have been left to conditions. So what Mr. Hewitt's saying does give me some concern that the process becomes a closed process from here on in. And I would just express some concern about that.
Your point taken. My understanding from Mr. Hewitt's submission that it's not for him to make his council policy on these matters, just on the hoof as part of his response. But I suspect he'll take on board the information he's heard today, and it will be recorded as part of your concern.
I mean, it certainly is just an Aarhus Convention point in terms of transparency and access to environmental information.
Right, thank you very much. Mr. Nesbitt, did you want to come in on any of those points, these kind of final things?
No, I think most of that didn't involve me. The only comment I'd make is that in my experience, if somebody expresses an interest in a particular document to a planning authority, then I've no doubt that they'd be able to get a copy at the appropriate time, and there's nothing to stop representations being made. And they would, of course, have to be taken into account.
Thank you. So that brings us to the end of the second hearing, or the third hearing, and to the end of the inquiry process itself. For those of you who have managed to make it through till Thursday afternoon at 4 o'clock almost, thank you very much for your efforts and taking an interest in this process. We've covered a lot of ground this morning about closing submissions and case summaries. We've had some additional documents, and we've discussed expenses. And we've also discussed in the first conditions session, which Ms. Shaw was not officially attending, and in this case, the potential for that we need to update and review some of the draft conditions that are currently before me. My intention is, from all of this, plus what happened in the preceding days, is to perhaps write a short note of what I consider to be the action points coming from the various sessions. It's not got any formal status, but I think it might be helpful if I record what I think is what we agreed on all these items. And if anybody disagrees, they would be able to tell me so quite quickly if they think I've got it wrong. But that would give you something to work from this point forward. I'll probably issue that through Christopher Kennedy, the case officer, either tomorrow or Monday. And that probably brings the inquiry to a close. So thank you very much for your attendance and efforts. Thank you. Oh, Mr. Finlay?
No, Mr. Nesbitt had his hand up.
Oh, right. Well, I thought he was waving.
Sorry. I will wave at the end, Mum. Just to pick up on your point about the note, which I think is really a helpful thing to do. Yeah, presumably that will allow for us to supplement the rest of the conditions. I know you made a comment about the noise conditions earlier, but that would that provide for some timescales for us to submit a further version? Yeah. Okay. Thank you very much. Kind
of continue on from an earlier discussion where we were looking at allowing for some timescales to redraft and refine some versions of the conditions.
Excellent. Thank you very much, Mum.
Thank you very much, and I'll say goodbye, and I will wave. I'll wave this time. Bye.
Thank you very much, Mum.
Thank you.